Oh, yes. Who? Why? No, we'll take it up. Don't worry. You'll do it. I'll help you out. Don't worry. 2011 matters, no adjournment.
My lord, if I may, one accommodation, my lord, if I
No adjournments.
My lord,
No adjournments, Mr.
no
Counsel.
adjournment, not adjournment, my lord. Mr. Goswami is leading in this matter. He has the matter in court number 1, my lord, which is sent by the Supreme Court to be taken.
We will accommodate for the time being if
Yes,
necessary, but no adjournments.
Yes, ma'am.
Item number 1.
Lordship, we are being led by Senior Counsel UK, Senior Counsel UK, Lordship.
May I please, ma'am?
Yes.
My lord, the petitioner before my lord was working in the secretariat of the governor. He entered in 76, got promotions in 2003. He became the joint secretary. Thereafter, my lord, he retired in 2006. In the meantime, my lord, a proposal was mooted by the governor's secretariat to create a post of additional secretary for him, my lord. That proposal went to the personnel department. Personnel department approved it with the condition that this post would be there till he survives. He is there in the service. After that, the post would be abolished. This went to the finance department. Finance raised a query that in the 2008 ROP rules, any post no post can be created for an individual. And accordingly, the proposal was sent back for a fresh assessment by the personnel department in view of the 2008, my lord, ROP rules. Now, this proposal comes back to the secretariat of the governor, because secretariat of the governor, my lord, with the approval of the governor, raises a proposal to the personnel saying that this post we want him to be upgraded because there is stagnation in the whole service. People are working for years and years together without any promotional scope. So if this post is created, then that stagnation would be under secretary to deputy secretary to joint secretary would be removed. This goes to the personnel department. Personnel department approves that. It comes back and my lord, matter is placed before the finance. Now the finance sits over the matter, my lord, till my date of superannuation. After around 55 days of my superannuation, they send back the file saying that the man has now superannuated. There is no need to look into this proposal. And the matter rested first, my lord. We approached this on. The only thing, my lord, because I was holding the post of secretary also, my lord, for a long time, because the secretary who had moved out, I was given in charge. My lord, when the post was created, I would have been, my lord, benefited with a scale of pay, which would have had an effect on my pension, my lord. That I have been deprived. This is my limited case before your lordship, my lord. And the proposal that was sent, my lord.
Now tell me whether the personnel department or the governor's secretariat can create a post.
No, the post can be created with the approval of the finance department. The chief secretary approved to that. Personnel approved to that. Second proposal, my lord, the finance did not take any decision. It just kept the proposal and, my lord, after I superannuated, it returned back the proposal.
No, the finance have a reason out there saying it is not that the finance did not give a reason.
That reason, the first account that they have given in the affidavit, they have said that because of the ROP rules, we are not inclined to do that. But, my lord, in the second proposal that was put up, there is a detailed note as to why this post is to be created. There is a detailed note. My lord, that was never looked into, my lord. That's my case, my lord. If my lord can take up my reply to the affidavit filed by the respondents, by respondent number 2, my lord. It was filed on 23/2012.
Paragraph 3.
No, my lord would come to the proposal.
Your
At
thing is,
page
your reply is that paragraph 3.
3, and the proposal is at page 11. That would be irrelevant.
No. Your reply is that paragraph 3.
Lordship.
Your reply is not, however, convincing.
My lord will only have that paragraph 11, page 11.
Page 11, there is no reply. There is no reply. Page 11 to the affidavit in reply.
He was replied, page 11, 9, you know? Yeah, the affidavit runs to 14 pages.
Your affidavit in reply.
Reply to affidavit by the respondent number 3, madam. (23) 2012. I replied, I replied.
There is no affidavit to the effect.
I'm so sorry, madam. My lord can have this, madam.
There is no affidavit to the effect.
Maybe my lord was not tagged.
Hmm?
Maybe it was not.
When did you file it?
My lord, it was filed on 20.
Why it is not here? Oh, you file it. Stop, stop.
23 2012. We got to find it.
Are we to file it now?
B filer, B filer.
Which doesn't appear in any of these things. Here only there is an affidavit filed on 13/7/2012
Lordship.
to an affidavit in reply filed by the petitioner against the affidavit in opposition of the respondent number 2.
Yes, my lord. Then there is another one.
An affidavit has been filed by respondent number 4.
4.
No affidavit.
2, 3, 4 have filed affidavits, and the reply is there, my lord, on behalf of the petitioner to the affidavit filed by the respondent number 3.
It is not on record.
My lord, can I make a search and come back? That's the affidavit. It's filed on 23 2012.
I was in it. Hello, green file.
B file is
Nila file
it's
to-
not there, madam. It's not there. It's
Then?
not there. That proposal, my lord, at least that proposal at page 11, my lord can just peruse that. Can I
You got
take
a
my-
copy? No, it is not filed.
No, they don't have a file. only.
You have taken the extra file. Why it is not available?
My lord, this document can be verified, my lord, from the record.
Now, this is a letter which has been written by the commissioner and secretary.
My lord, this is the proposal which has been put up by the commissioner and secretary to the governor before the personnel department and the chief secretary, which was subsequently approved by both the authorities. And the matter went to the personnel department finance at, my lord, page 13.
No, the finance has given some reasons.
No, my lord, in the reason that has given in the file, my lord would find at page 14 of the affidavit
No, the finance affidavit is
there.
serial number, this one. Yes.
Yes.
The
Respondent number-
finance affidavit is clear out here. Kindly
Lordship.
come to paragraph number 4 of
Lordship.
the affidavit in opposition.
Lordship. So and so, that as regards the statements when in so and so, the petition begs to say the petitioner is allowed to take over charge as so and so. Or hold charge of so and so. He was not granted charge allowance for holding the higher post of finance department because non-fulfillment of so and so. Moreover, the post so and so. My lord, the relevant is para 6.
No. See the finance affidavit,
Yes, that
para 4.
fourth. That they say, my lord, that I will not be entitled to the higher pay scale for holding the post of secretary. Fine, my lord.
No, they say that
Lordship.
he was not granted the charge allowance for holding the higher post by the finance department because of non-fulfillment of condition 2A and 2B of FR
49.
corrected by so and so.
Lordship.
Moreover, the post of the governor
Belongs-
secretary belongs to IS cadre and not a promotional post to be filled by the so and so.
Lordship.
So that is what.
One. That
Now-
I'm not, my lord. 6 months.
Now we are concerned with paragraph number 6.
That as regards the statements made in para 6 to 10 of the writ petition, the deponent respectfully begs to state that the proposal for creation of an ex-cadre post of additional secretary for promotion of the petitioner was received in the finance department on 18/9/2009 from the governor secretary. The personnel aid department accorded its no objection to the said proposal of the governor secretariat subject to concurrence of the finance department. The proposal of the governor secretariat was returned by the finance department with the advice to re-examine it in the light of the new ROP rules when issued. The governor secretariat resubmitted the proposal-wide endorsement dated 9/2/2010, which was again returned to them with the finance department-wide endorsement dated so and so with a request to obtain fresh views of the personnel department on the proposal with reference to recommendation number 3 of the general recommendations in chapter 10 of the report of the Assam Pay Commission 2008. The governor secretary resubmitted the proposal of the finance department with the view of the personnel department, while its endorsement dated 9/6/2010. While the proposal was under examination of the finance department, the officer concerned attained the age of superannuation on 30/6/2010. The proposal was returned accordingly to the governor secretariat by the finance department, while its endorsement dated 31/7/2010. And my lord, that 31/7/2010 does not speak of anything else, saying that the man has retired, this proposal is there.
Let us further. Yeah.
It is pertinent to mention here in that, as per recommendation of the Assam Pay Commission 2008, no post is to be created to facilitate promotion of a government employee. As mentioned above, no post is to be created to benefit any particular government employee, and this principle has been accepted by the government with the approval of the cabinet, as per recommendation of the Assam Pay Commission 2008. As such, despite approval of the personnel A for creation of the post of so and so in the governor secretariat for allowing promotional benefit to the petitioner, even after the above mentioned recommendation of the so and so, the finance department was not in total agreement with the personnel aid department and was contemplating to inform the governor secretariat accordingly with reference to the endorsement dated so and so. However, before the finance department could communicate its final decision to the governor secretariat in this regard, the petitioner retired from service and hence the relevant file of the governor secretariat was returned with endorsement dated 31/7/2010 as mentioned above. Further, the deponent begs to state that there does not appear to exist any rule under which appointment may be claimed by a government employee against a non-existent post. Now, my lord, that factor is clear from the, my lord, endorsement of the governor secretary dated 26/9/2010, wherein, my lord, they had given the utility of this. The ROP says just for the purpose fund check, you cannot create a post for giving benefit to a post. But my lord, if the utility is given and that utility has been clearly set up, that see, the secretary who is the highest authority, he keeps on moving out. There are a number of activities which have to be carried out. We have a post till the post of joint secretary. So we require a post of additional secretary. So kindly create that post so that the liaising works can be done. 2, that's 1, my lord. 2, there is big stagnation in the whole system.
But that is not the reason why it has been given. Here, all the documents which have been shown, even if you see
Lordship,
the affidavit filed by the respondent number 4, that is the governor's affidavit.
Lordship,
Kindly see out here.
Lordship.
Kindly come to paragraph number 4 onwards. You see, paragraph 3. The
Lordship.
proposal for creation of a with the approval of so and so returned back prior to that was promoted so and so. He served in an superannuated. Regarding inability to incur proposals, since he is already an alias. Again, the proposal was resubmitted with the file of so and so. Had no objection for creation of a one ex-cadre post for giving promotion. So this is only for him.
My
This is
lord,
personal to him.
no, my lord. That statement, my lord, will have to read in terms of the proposal that was submitted.
But this is what has been stated by the governor.
My lord, the proposal, my lord, will show otherwise, my lord.
But here, kindly see at paragraph
I
number
got it,
4,
but-
this is only done specifically for him.
My lord, that I got it specifically. That is what is stated here. But my lord, the proposal that is there, my lord,
But
it-
the proposal does not form a part of the record.
my lord, unfortunately, that affidavit, my lord, is not before your lordship.
No, that affidavit is not mentioned anywhere, even in the office note also.
I'm so sorry, my lord.
Then
The affidavit was filed, my lord. It was filed on 23/2012.
it's not there.
My lord,
But-
can I make an attempt to just make an attempt to, my lord, find out that affidavit?
Where?
In the registry, my lord.
By 2 o'clock.
My lord, today, 2 o'clock, I would have some different. Tomorrow, my lord,
No.
I'll have some difficulty, my lord.
All these 7 matters are to finish today. Today is the last date. I can give you till 2 o'clock to find out with the help of the registry in my office. If you can find out that affidavit, or you'll show me that affidavit or but whatever has happened out
My
here
lord,
is-
I'm not even, my lord, asking my lord to go into the affidavit. I'm
No,
only
if
with
it
the
is,
proposal.
it is because there are 2 aspects. One is you are saying that this is for the purpose of removing the stagnation.
My lord will have that.
And on the other hand, the governor's affidavit says only for him. Have you got any, now is there any additional secretary in the, additional chief secretary, na?
Additional secretary.
Additional in the governor's secretariat? What is this? Perhaps not business. This matter was there in the from Monday, this list was there. Why didn't you find it out?
My lord would have the earlier proposal, my lord, at page 25 of the affidavit. This is in continuation of that they have given. Here, the justification is only for additional secretary, my lord. And they wanted a post to be created.
Now do you
There's
want,
no post.
now do you want an additional post of additional secretary?
Only, my lord, for the purpose of fixation of my pension. my
No,
lord.
no, for others,
Lordship.
for others,
If they, my lord, the issue here is the my lord will have page 25, last line. my lord. Thereafter, my
no,
lord will
just
take
show me that this court can direct for creation of a post, supernumerary post for your curse.
My lord cannot. This court cannot. This court cannot. Only thing my lord can do is ask the finance department to look into the matter.
What, for what?
Because, my lord, they have not examined that proposal in the manner the proposal was put up. The
No,
utility-
the proposal,
utility-
the last of the proposal, because the personnel department also says, okay, we are agreeable, but let us have the concurrence of
No,
the
the
finance.
mistake happened there, my lord. The mistake happened there. The mistake, if I may say so, happened there. The governor secretariat wanted one post of additional secretary. What the personnel department said, okay, you create, but it will die with the superannuation of the person. That was the mistake, my lord. So the plea was taken by the finance department that you cannot create a post for promoting a man. That was never the intention, my lord. If my lord can come to page 25 of the affidavit, of the writ petition. That is where the, my lord, error occasion.
Because if you see these communications, more particularly those communications which were there, more particularly Annexes 7 onwards
Lordship.
of the governor,
Lordship,
has been rendering survey in personal quality. He has endorsed the so and so with amicable, I sincerely and wholly appreciate.
that
the
is his
individual
appreciation
service.
certificate.
Discharge so and so.
Relevant would be page 25.
Commissioner, now kindly see Annex 10.
Yeah, that's the third paragraph, man.
Personally is
Requested to reconsider the proposal for creation of post of additional secretary, secretariat service for accommodation of so and so against the post on seniority basis. The proposal, if accepted, the Department of Personnel will enable us to consider promotion of other officers like superintendent, undersecretary, deputy secretary, who are all in superintending stage, and members of staff of so and so establishment who are continuing more than 16 years in the same post. These are instances where there are instances where the state government was earlier pleased to relax the condition of and ordered for promotion who have completed 2 years of service with so and so. The required information of the matter for examining the proposal may be perused once again at 8 and 9 note sheet. In view of that, it's requested to convey the concurrence of the personnel department at the earliest. Now, my lord, the personals. Personnel department have no objection to the creation of one ex-cadre post of additional secretary for giving promotion to so and so joint secretary, subject to the condition that the post will stand abolished as and when so and so quits or he superannuates, subject to the concurrence of the finance department. This has approval of the chief secretary. So this is where, my lord, the proposal got, and I was, my lord, fixed. This is from where
The word concurrence gives an enormous power to the finance.
that's true. But the finance, my lord, took up the plea.
2 days before, I was looking into one of the lectures of Justice Rohinton Nariman while he was explaining as regards SP Gupta and all, and more particularly the 1992 death judgment.
Second.
Said the word consult has become was interpreted to be a concurrence. And as such, for the purpose of appointment of a judge, earlier which was merely a consult, now has become a concurrence. And with the concurrence means the power has become much more.
True, my lord. And that's why, my lord, the delay.
Yes, you are standing without a brief. Tell me. Now that is here also. They are still
Yes.
having the commissioner and secretary.
Yes.
The basic reason why the governor's secretariat was saying that look here, this commissioner and secretary keeps on moving around and he keeps on going on tours and all. And as such, it becomes difficult. There are a lot of things for a judge's leave or a chief justice leave, chief justice appointment, or the appointment of various other officials out there. These are to be done by a person of having the stature of an additional secretary. That was the reason why it was done so. But it was done in a very late in the day because it was done on 19/5/2010. And then the matter went to the personnel department. The personnel department again have put the back to the finance and saying that finance concurrence is required. And the finance said that, okay, now it has gone.
Retired, finished. Only my grievance, my lord, if any, would be that the finance did not take it.
Now, that is why I am asking him. Can this court? Yes, there are some cases where the court directs for creation of a supernumerary post. But in these circumstances, can the supernumerary post be given? And if it can't be given, how can I grant the
The
relief?
only thing, my lord, relief your lordship can grant me is requiring the finance department to examine this proposal in the manner it is required to be done. Because they have admittedly not done it. They returned the file saying that now these are, my lord, things which were there.
No,
in
no,
the
but the proposal which was there
lordship.
was for creation of an additional secretary post.
Lordship,
Now, how will that help you?
No, if that is created with retrospective.
Because if you see these documents
Lordship,
on which you are saying that this document is a very important document which has been filed by way of an affidavit, which I don't find it.
unfortunately.
But this document only says for creation of an additional post of secretary. Nothing,
Hello?
none. It doesn't say anything about him.
No, but it says, my lord, because my lord, this proposal has to be read in terms of the earlier, my lord,
Earlier was for creation of a supernumerary post.
lordship, no, it was for creation of an additional post, a secretary.
No, understood.
My lord,
If
page
we see
55,
out here, but then
25.
also it was stated to reconsider the proposal of creation of so and so against the so and so.
for accommodation of so and so.
Yeah. If accepted by the will enable to consider promotion of other officers like so and so who has supernumerary so and so, so and so. No, understood. This is there, but then the personnel department further reduces the scope only to making it supernumerary.
That's where, my lord, the problem.
Now, again, it has been, the finance returns it back, and then this fresh proposal goes where there is not a single mention about you.
No.
Now, if this, should this court now ask the finance to look into this, how is it going to help you?
Because my lord would have the first paragraph of that order.
Yeah.
Because finance rejected it because that utility question came, you cannot give promotion to a person before only for him, my lord. Therein, my lord would see, referring to the department wise general convention number so and so, accepted by the government, it has been urged to obtain fresh views of the personnel department. The recommendation number 3 suggests that new post without any functional utility should not be created only to facilitate promotions. It is pertinent to mention here in this connection that the proposed post of so and so.
So now, therefore, new post can't be created unless there is a functional utility. Now, here it therefore says that these are the functional utility. And if these are the functional utility, now create a post, then asking them now for somebody else.
It would not come to me until and unless there is a retrospective. My only grievance was, my lord, the finance department sat over the matter.
In fact, your matter was that, look here, these people have delayed. And because of that, I didn't get it. And as such, I should be given from the date on which the chief secretary has recommended. That was your simple case.
Simple case.
But by the time everything has expired,
It's
now, everything has lost its
shield. That's it, ma'am.
because that post now to, because this
Because now-
proposal, if I give, that will be helping somebody else.
But without that retrospective effect.
One thing
But
the people may say that yes, on account of
Mr. Jeevan Chandra
Mr.
Singh,
Jibon Chandra Desai,
He has got
there is a
this.
post of additional secretary held. So whatever happens, they can
that
put some.
would be too far. Madam. That cannot be in a repetition. This I cannot go beyond this.
Yes, without a brief, tell me.
My respectful submission will be, there were 2 proposals. The first proposal was attended to by the finance department. It is the categorical plea of the petitioner, madam. The second proposal was not attended to by the finance department, which is the default committed by the finance department. In the meantime, he has retired. Lordship will kindly see the 2 proposals. The first proposal, it was categorically stated that it was a supernumerary post. Second proposal, in my respectful submission, subject to Lordship's correction, is a convenient afterthought by my lord, by the governor secretariat. So only to accommodate the petitioner, my lord, changing the color, because it is a continuous decision-making process. 226 Lordship will be examining the decision-making process, not the decision itself. So therefore, Lordship will kindly see, my lord, the Zenas. The Zenas was, my lord, for creation of a supernumerary post. In
And who is
between,
appearing for the governor's secretariat? They have filed affidavit. Who is appearing? You can appear. You are appearing. Has the governor's secretary thereafter mooted again the post of additional secretary or left it there?
Left them.
Huh?
Left them.
There? Hello. Thanks.
And the first, my friend has said, the first return by the finance department was before the ROP rules came. Only they said ROP is coming. So on that basis, when it comes, you examine. Really. There was nothing at that first rejection. Beyond this, my lord, I can
the petitioner herein has filed the instant writ petition because your prayer is also for ex-cadet, not for creation of that. Your prayer is therefore for ex-cadet supernumerary post for. That is why I said, now your case was simple.
Simple, madam, because of the delay, yes,
And if this matter would have been taken up in 2011, 12,
I would have got the relief.
something.
Something I would have got. Today, madam, it's too late.
Because now if this court has to do it, either has to show that the finance department had to abide by the directions of the commissioners, by the governor's secretary, which I can't.
No, no, my lord.
That won't be proper. The case of the petitioner, no, the petitioner herein is aggrieved by the inaction on the part of the finance department of the government of Assam in not granting the concurrence for creation of an additional, for creation of a post of additional secretary in the governor's secretariat, thereby depriving the petitioner of his promotion to the post of additional secretary to the governor's secretariat, and as such have sought for a mandamus directing that to grant benefit of an ex-cadre promotion to the post of additional secretary to the governor's secretariat retrospectively with financial benefit with effect from 15/9/2009, and also to release the area salary in the pay scale of the additional secretary from 15/9/2009 to 36/2010, and also to compute the pensionary benefits on the basis of the said pay scale. The facts involved in the instant case is that the petitioner joined the governor's secretariat in the year 1970, in the month of September 1976, and was promoted to the post of undersecretary in the year 1991. In the year 1997, the petitioner was promoted to the post of deputy secretary, and in the year 2003, the petitioner was again promoted to the post of joint secretary. The petitioner was also, during this period of his service, the petitioner was also allowed to officiate in the post of the secretary for several times since 1997 to 2006 on the orders of the governor of Assam during Assam. The relevant facts for the purpose of the instant dispute is proposal for creation of the post of additional secretary in the governor's secretariat was mooted, and the then honorable governors approved the same. The said proposal was submitted on 17/2/2009 to the Commissioner and Secretary, Personnel Aid Department for concurrence regarding creation of the post of Additional Secretary. The Personnel Aid Department by its endorsement dated 15/9/2009 gave its no objection to the creation of a one ex-cadre post of the Additional Secretary for giving promotion to the petitioner, subject to the condition that the post shall stand abolished as and when the petitioner quits or superannuates, subject to the concurrence of the Finance Department. The endorsements so made by the Personnel Aid Department makes it clear that the proposal which was mooted from the Governor's Secretariat for creation of an additional post, for the creation of the post of the Additional Secretary, for the grounds and reasons stated in the endorsement dated 17/2/2009, was accepted only for creation of a supernumerary post for the purpose of facilitating the petitioner to be promoted to the post of the Additional Secretary, and the cessation of the existence of such supernumerary post was made coterminous with the services of the petitioner. The Finance Department of the Government of Assam who received the said proposal on 18/9/2009 was returned the same with the advice to re-examine it in the light of the new ROP rules when issued. Thereupon, the Governor's Secretary resubmitted the proposal by the endorsement dated 9/2/2010, which was again returned to them by the Finance Department by the endorsement dated 14/5/2010 with the request to obtain fresh views of the Personnel Aid Department on the proposal with reference to the recommendation number 3 of the general recommendation in chapter 10 of the report of the Assam Pay Commission 2008. At this stage, this court finds it relevant to take note of an endorsement, take note of the proposal so submitted on 26/5/2010 by the Governor's Secretary, by the Commissioner and Secretary to the Governor's Secretary, a copy of which was produced during the course of hearing. A perusal of the said proposal shows that the Commissioner and Secretary of the Governor's Secretary had made an endorsement that the recommendation number 3 of the Pay Commission in Chapter 10, accepted by the government, suggests that new post without any functional utility should not be created only to facilitate promotion. In that view of the matter, the said endorsement mentioned the reasons, the functional utility of the post of the additional secretary in the Governor's Secretariat. It further reveals what happened. What did the personnel department do then?
I think they re-endorsed their earlier, the earlier view, madam.
Where is it?
But it's not there, it's not there. But that can be inferred, madam.
Personnel is departments is here. There's an affidavit.
Yes, they have an affidavit.
Ah.
Deepak Kumar Sahu.
The personnel A department thereupon again reiterated its earlier view, stating that there is no objection for creation of one ex-cadre post of additional secretary for granting promotion to the petitioner. But observe that the said endorsement was subject to the concurrence of the finance department of the governor of Assam, of the government of Assam. It further reveals that in the meantime, while the proposal dated 26/5/2010 of the commissioner and secretary to the governor Assam was pending concurrence of the governor of the finance department. The petitioner retired on 30/6/2010, and thereupon on 31/7/2010, the said proposal was returned to the governor's secretariat, stating that as the petitioner had already retired, had already superannuated on 30/6/2010, the governor's secretariat may reconsider the proposal. The petitioner, therefore, being aggrieved by the inaction on the part of the finance department of the governor of Assam, of the government of Assam, in granting the concurrence for which he could not be promoted to the post of the additional secretary, and thereby being deprived of the pay scale and the consequential benefits, have approached this court by filing the instant writ petition on 18/1/2011. it reveals from the records that this court, by an order dated 21/2/2011, had issued notice the records for the revealed that the personnel department, that is the respondent number 2, personnel A department of the government of Assam, that is the respondent number 2, the finance department of the government of Assam, that is the respondent number 3, and the principal secretary to the government of Assam, that is the respondent number 4, have filed their affidavits. In the affidavit filed by the respondent number 3, it is the categorical stand of the finance department that no posts can be created to benefit any particular government employee, and this principle have been duly accepted by the government with the approval of the cabinet as per the recommendation of the Assam Pay Commission 2008. It was further mentioned that though the personnel A department had granted the approval for creation of the post of additional secretary in the governor's secretariat for allowing promotional benefit to the petitioner even after the recommendation of the Assam Pay Commission 2008, the finance department was not in total agreement with the personnel A department and was contemplating to inform the governor's secretariat accordingly, with reference to their endorsement dated 9/6/2010. However, before the finance department could take the decision, the petitioner had already retired on 30/6/2010, and accordingly, the relevant file of the governor's secretariat was returned to the governor's secretariat for reconsideration. The personnel A department in its affidavit filed on 29th of March 2012 had stated that the personnel A department had no objection for creation of one ex-cadre post of additional secretary for granting promotion of the petitioner, which accordingly was intimated to the governor's secretariat. But the same was made subject to the concurrence of the finance department of the governor of Assam. The respondent number 4, that is the governor, that is the principal secretary of the governor of Assam, and in paragraph number 6, had also filed an affidavit in opposition, wherein in that paragraph number 6, it was mentioned that the finance department of the governor of Assam, of the government of Assam, was requested to expedite the matter at the earliest by the commissioner and secretary to the governor by the communication dated 6/5/2010 due to the delay in the process since the proposal was sent on 10/2/2010 with the approval of the personnel A department. It was mentioned that the finance department again sent back the file seeking fresh views of the personnel A department in the light of the new ROP 2008. by the endorsement dated 14/5/2010. Thereupon, the file was again moved to the Personnel Aid Department and they made an endorsement on 1/6/2010 whereby it gave no objection to the creation of one ex-cadre post of the additional secretary, as well as conveyed by them earlier also. It was further mentioned that the file was endorsed to the Finance Department on 9/6/2010 for necessary concurrence on the proposal as a special case, since the petitioner was due for superannuation on 30/6/2010. However, the Finance Department returned the file stating that the Finance Department observed that the petitioner, for whom the ex-cadre post of additional secretary proposed to be created had already attained the age of superannuation on 30/6/2010, and for which the proposal may be reconsidered by the Governor's Secretariat and communicate by their endorsement dated 31/7/2010. It further reveals from the records that the petitioner had filed a reply to the affidavit filed by the respondent number 3. A respondent number 2, wherein it has been mentioned that the Finance Department mentioned that as the Governor of Assam is the highest constitutional body of the state, and there was a recommendation being made by 3 consecutive governors, thus the Finance Department should not have kept the file pending till the date of retirement dated 30/6/2010, as the file was placed before them well in time. It was further mentioned that the Chief Secretary of the state government had also approved the same on 15/9/2009, and the file thereafter placed before the Finance Department for its concurrence. And the Finance Department kept the file pending, and on retirement after 55 days returned back with a comment that a concerned officer is on superannuation. Mr. Nair, I have already taken note of this. I won't say it because it is not on record.
Just checked up, Manoj, the status in the website shows filing of this one.
Does it?
Yes, I'll just place it, Manoj. $23,000. Maybe some defect was there, Malad. That's why it may not have got connected and it might have gone.
It has also been, it is also relevant to take note of that an affidavit in reply was also filed by the petitioner to the affidavit in opposition filed by the respondent number 3. In the said affidavit in reply, the endorsement, the proposal of the governor, proposal so submitted by the commissioner and secretary to the governor of Assam dated 26/5/2010, as well as the endorsement of the Finance Department dated 31/7/2010 was enclosed. I've heard the learned counsels for the parties and perused the materials on record. The issue involved in the incident petition simply stated is that the petitioner is aggrieved by the inaction on the part of the finance department in not granting the concurrence for creation of his of a post of an additional ex-cadre post, for creation of an ex-cadre post of additional secretary, for which the petitioner could not be promoted while he was on service, while he was in service. It, however, appears that the finance department taking into account the initial proposals so submitted on 17/2/2009 and the endorsements so made on 15/10/2009, 15/9/2009, returned the proposal stating inter alia that for the purpose of that a post cannot be created for the purpose of facilitating a promotion of an officer.
No.
As the same would be contrary to the recommendation number 3 of the general recommendation in chapter 10 of the report of the Assam Pay Commission 2008.
But that issue had not come up at that point in time because the recommendations were not out. It came out in 2010. My lord will have that affidavit of the respond number 4. Therein, my lord would have para 5. My lord. They said when the ROP comes, you submit it fresh.
Irregular, no? No. Had the finance department returned the proposal with an advice to the governor's secretariat to re-examine it in the light of the new ROP rules when issued. Thereupon, it further appears that the governor's secretariat thereupon on 9/2/2010 again submitted the proposal.
This was a fact with that.
Directly to the finance department, wherein the finance department again returned the proposal with an endorsement dated 14/5/2010 with a request to obtain fresh views of the personnel A department on the proposal with reference to recommendation number 3 of the general recommendation in chapter 10 of the report of the Assam Pay Commission 2008. It is under such circumstances that the third proposal was again submitted on 26/5/2010. Thereby to meet the deficiency, on 26/5/2010, wherein it was mentioned
Functional utility. Right.
Wherein, in order to overcome the recommendation number 3 of chapter 10 of the Assam Pay Commission rules, rules, na?
Recommendations.
Assam Pay
accept-
Commission recommendation,
The rule, the recommendations that was accepted by the government and it turned into ROP rules, Assam Pay Services, revision of pay rules 2010.
so this is recommendation.
This is a that was which was accepted.
Recommendation 3 of chapter 10 of the Assam Pay Commission, Pay Commission 2008.
Which was accepted by the government.
Last line to kill it. Hey, last. Of chapter 10 of the Assam Pay revision of pay recommendation after Assam
Assam Pay Commission,
Commission recommendation
2008.
had mentioned the functional utility of the post of the additional secretary. This proposal, when submitted to the Personnel Aid Department, the Personnel Aid Department retreated its stand similar to its endorsement dated 15/9/2009. Thereby stating that an ex-cadre post, that the Personnel Aid Department had no objection for creation of an ex-cadre post of additional secretary for granting promotion to the petitioner and making the said post coterminous with the services of the petitioner, subject to concurrence of the Finance Department. The said endorsement made by the Personnel Aid Department was, however, contrary to recommendation 3 of chapter 10 of the Assam Pay Revision, Assam
Pay Commission.
Pay
Recommendation.
Revision 2008. Inasmuch as it was the mandate which was duly accepted by the cabinet of the SAM, by the cabinet, accepted
government.
on the basis of a cabinet decision, that there can be no creation of a post for the purpose of facilitating a promotion. Under such circumstances, this court is of the opinion that as the creation, under such circumstances, this court is of the opinion as the basic intention for creation of the post of additional secretary was only for the purpose of facilitating the promotion of the petitioner to the post of additional secretary while he was in service. And as the same was contrary to the recommendation 3 of chapter 10 of the Assam Pay Revision, recommendation, There was no illegality on the part of the finance department in not granting the concurrence for the creation of the post of the additional secretary during the service of the petition, during the period the petitioner was in service, that is up to 36/2010. In that view of the matter, this court therefore is of the opinion that the relief which has been sought for by way of the instant petition that is for creation of an ex-cader post, and therefore in that view of the matter, this court is further of the opinion that the relief which has been sought for is in effect a mandamus, it is in effect a direction being sought for creation of a supernumerary post for the grant post of additional secretary in the governor's secretariat for the purpose of granting the petitioner the promotion. Granting the petitioner retrospective promotion to such post which is yet to be created. In the opinion of this court, such a relief cannot be granted by this court as the same would run counter to the recommendation number 3 of chapter 10 of the Assam Pay Revision so and so. Under such circumstances, this court does not find any merit in the instant petition, for which the petition stands dismissed.
Much obliged.
Obliged.
Mr. Nair, ask your junior to give the names, huh? So that nowadays I put it like the court number 1. It'll be easier.
Item number 2.
Hey, without the brief also you got it. Now, with the brief and then additional affidavit in reply.
We are obliged.
Yes.
Mr. Goswami is in court number 1 is on leg.
No, enough is enough. I go into review 1 hour, 1 hour, 15 minutes. Okay, number 3, we'll take it.
Right.
No, rubbish. Ananai, hi. What is wrong? Item number 3 and 4.
3 and 4.
Connected.
My lord, due to some medical urgency, Mr. R. Islam is still at the hospital.
No. Sorry, you do it. But it is one matter. 3 and 4. Yeah. 3 and 4 are both different type of matters. Anyway, we'll take 3 first.
So far as item 3 is concerned, it is one of the issue herein whether the petitioner would come within the ambit of new pension rules or the old pension.
Is it so?
Yes. Now,
These people were what?
these people, my lord, they were,
Oh, yeah.
Lots of, in item number 3, although my name has been shown, the client has withdrawn the bid from me.
Fantastic.
now these petitioners were appointed in various grade 3 and grade 4 posts. without,
No, I remember.
yes,
These petitioners were initially appointed in various grade 3 and grade 4 posts. There were various litigations. The courts have been passing orders after you had also terminated them. And
Yes.
there were orders passed to that effect not to terminate unless you have a fresh recruitment process.
unless and feasible.
Now you had a fresh recruitment process. Now they want that the earlier period should be taken into
Earlier
account.
period should be taken. That is the plain and simple issue. And this honorable court on various occasions had interfered with the orders of terminations of the petitioners on the ground that there was a violation of natural justice. They were, it appeared to be termination simplicity.
Your simple thing is they were never within the cadre of the government.
Absolutely. And
And as such, as they were not within the cadre of the government, the question of they getting the benefit or past service does not arise.
does not arise, and more so because of the fact in the affidavit in opposition filed on behalf of the Director of Land Records, it has been categorically pleaded out there, my lord, that their appointments were absolutely illegal and my lord, irregular.
No, but then also you have protected. You lost all the wars out there, battles. Now you want to win the war.
The protection, my lord, will kindly see, my lord. Those interference by this honorable court, with all respect, my lord, was mainly on the ground that, my lord, we could not have terminated them simplicity. That's it, my lord. Not on the merits. This honorable court did not, had not on any single order, lordship will find on record, had entered into the merits of the claims of the petitioners. So this is how, my lord, the matter stands.
Chalo, let me dictate. I'll come 11:30, 11:45, I'll come and dictate. that.
Lordship, I'll be relying on my lord's decision in Purnima Hore.
Not necessary,
Otherwise also.
because here is the case. They were not within the cadre of the government.
Absolutely.
This is ministerial.
Ministry.
Ministerial. So you have a cadre.
Yes,
So you were never within the cadre of the government.
yes.
Earlier also, they have not, at that point of time, they were not. What happened to the judgment? Appeal? Nothing?
Yes, my lord, few appeals have been preferred, my lord, by the drop teachers category.
Blackboard?
Blackboard, my lord, so far one, only one,
Then other one, excess.
excess one.
Then it's six schedule.
Six schedule, not yet. Six schedule, not yet. Now those appeals have been clubbed, my lord.
Let me,
Even I have,
that was a PWD matter.
PWD, my lord, since he represents PWD, my lord.
There, that was a case where actually there was a challenge to the rules.
Hmm.
So initially they filed in the year 2009, challenging the office memorandum. Then they made an amendment challenging the rules. So the matter was there before the division bench. And after the division bench, the council submitted that we are not challenging the rules. And as such, the matter was relegated back to the single judge. And then that matter came before me. That is a matter of 2011.
Yes, I remember, my lord, I was present in the court,
Yeah.
midst of a hearing.
There, these people were earlier working in the PWD. Then pursuant to a regular selection, they were brought in. Now they were claiming the past benefits out. So that case is fairly covered by this. How do I get the date number?
We'll find it out.
Mr. Barbujari, why didn't you find out that one? Ask Mr. Nayak also. I'll take up item number 2 now for the time being. Just find out, because then it becomes easier for me.
Yes, yes, my lord, I'll have a talk with Nayak.
Yeah, just find out.
Yes, yes.
That judgment will squarely cover it.
My lord, I'm so grateful.
Because they were taking up the plea of that Sandeep Sharma.
Yes, Sandeep Sharma.
They were taking. I said that Sandeep Sharma does not come into the picture because
Yes.
that was a selection which was held.
Yes.
And in fact, there was another aspect. No. That was. No. That was a different, the facts were a bit different. They were though working, they were there in the select list. The total number of posts were initially sent was 94. Then it became 103. 103 persons were duly appointed prior to the coming into effect of the new pension rules. Then comes these people who were appointed in 2005. So they say about the select list then, but they didn't have a right because of that Sandeep Sharma's judgment did not apply because the select list actually had exhausted. They couldn't have been appointed there.
Yes.
You just find
My
out.
lord, my lord.
Yes, Mr. Goswami, your matter.
Sorry, my lord, I was on legs in court one, my lord.
Yes.
So the matter which the Honorable Apex Court had sent for disposal today, my lord. Anyway, that's over now. This matter relates to, is whether we are challenging the award of the Learned Labour Code dated 6/7/2010, my lord, whereby,
Did you give evidence in the labor court?
yes, we have. In fact, my lord, your lordship is aware of Ritz Theatre, Firestone, Delhi Cloth House, the trend, and in fact, Nitesh Kalpesh and another latest judgment of Justice Sapre. The trend is, my lord, when in a domestic inquiry, the management has a choice. The management can rely on the domestic inquiry. In that situation, the labor court will have to try the validity of the domestic inquiry as a preliminary issue. If the management fails, management will have to request for adducing evidence, and that request has to be allowed, my lord. The management gets a chance. That is one situation. It may be so happen that the management relies on the domestic inquiry and simultaneously adduces evidence also before the labor court. In that situation also, the labor court will have to first see whether the domestic inquiry is proper, not proper, valid, invalid, and come to a finding. If for some reason the Learned Labour Court comes to a finding that the domestic inquiry is invalid, perverse, in that situation, the Labour Court is entitled to look into the fresh evidence which has been adduced, the additional evidence. Now that has not been done in my case. Here, in this case before your lordship, the Labour Court has had both the evidence. Initially, the Labour Court went to the domestic inquiry and said, no, there is no violation of procedures. Then the Labour Court examined the evidences adduced before the inquiry officer, appreciated, reappreciated like an appellate authority, and came to a finding that it is perverse. The conclusion of the inquiry officer is perverse. And then came to a finding that no, since we have said that the inquiry is valid, only the evidence is perverse, therefore we will not go into the additional evidence which is tendered before the Labour Court. This is the finding of with utmost respect, of the Learned Labour Court, which according to me is erroneous. Now, the first error that the Learned Labour Court had, with utmost respect, committed is that because it was, well, here what was the case, my lord? Two of the,
You proved.
the delinquent.
No, there were 3 charges.
Yes.
Did you prove the charges 2 and 3?
Well, one was proved, my lord. Before
One
the,
is okay.
yes.
2 and 3.
No, but this is it for the Labour Court.
Understood. But what about the 2 and 3?
Well, according to the Labour officer, 2 and 3 was not proved. Now the question is, if that
Are you now saying the 2 and 3 was also to be proved? Was proved? No.
well, according to me, my lord, for some reason, if the Learned Labour Court comes to a finding that the inquiry officer report is perverse, that everything goes. Everything will go. Thereafter, the additional evidence is before the Learned Labour Court. Now, the Learned Labour Court will have to see it and come to a finding. this exercise,
Where is the preliminary issue framed?
that was not done.
But did you raise it in your written
Sir,
statement?
it is not necessary
No,
that
you
I have
have-
to raise it, my lord. Well, let me then play.
You have to raise it in your
With
written statement.
most respect, my lord.
You have to raise it
That's
in your
very
written statement
technical, my lord.
for
That-
framing a
That's
preliminary.
a very technical.
Your written
approach.
statement did not say anything that you are going to rely upon it.
Absolutely, because I am, that is why in the beginning I said that we have a choice. If I have, in my perception, if I have understood the decision right from which theater correctly, my lord, this is a choice. I have a choice immediately to say, no, you tried this as a preliminary issue, or simultaneously I may say that, no, I'm relying on this and I'm adducing evidence. If I do that, then it is the duty of the labor court to first decide. Here the labor court decided and came to a finding that the inquiry is bad. Thereafter, it was the duty of the labor court to see the additional evidence which was in front of the labor court, which the labor court did not do. That is my case before your lordships. And according to me, subject to correction, right from Ritz Theatre to the last page of this High Court, which I found with is that same trend. This is the trend that is going on. I may indicate that, but before that, if I may just, I'm sure your lordship have read the brief, but if I may just place the facts in my way, since your lordship is hearing the matter, if your lordship allows, I may just indicate that, my lord.
If I may say,
My lord,
the fact seems to be that there were two women.
yes,
They were charged. There were three charges framed.
my lord.
The first charge was obstruct.
Restrain and obstruct.
Charge 2, riotous. Charge 3, standing out of violation.
My lord.
Charge 2 and 3 have not been proved. Comes to charge 1. If charge 1 was such, is the punishment of dismissal proportionate?
Proportionate or not. Well, that is
More particularly
True.
taking into account,
True.
there was a aksaba.
True.
On which date there were these two persons who asked these people, you don't attend the duty. That is what has been proved.
correct. No quarrel.
Now, was the punishment proportionate?
Well, the proportionality part would have been relevant today if suppose the learned labor court had said that the inquiry is valid. Only then that part will come. Here is a case where the learned labor court has held the inquiry to be bad, perverse. Therefore, that part will not come now. Now everything is at large before the learned labor. This is my humble submission before your lordship. Now, your lordship would kindly first see page 23. Your lordship has rightly pointed out the charges from there. The first charge is you try to forcibly prevent the workers from their normal routine work. Now here, there are evidence also in front before the learned labor, before the inquiry officer, where from it is clearly shown that these two delinquent employees have obstructed, the words used are obstructed and restrained. Now, obstruct and restrain are not some mere, it is not, it doesn't mean that merely asking someone not to do. It means force. That
No.
element of force will come.
Oh, no, Mr. Kaushik. Mr. Goswami, there's nothing to that effect. These are two women out there. How
Well,
can you
not
say
just
that?
two women, my lord, along with that.
No,
other-
along with that, there's no charge along with others. You have not stated about anybody else.
But that has come out from the evidence, my lord.
No, but there's no charge. There's nothing. You have not put any charge that there were other people. What has been proved, only the charge which have been proved out there,
My lord,
the inquiry officer, was this. Kindly see this.
yes, you tried to forcibly prevent at page 20, what 23, your lordship referring to? The charge sheet you're actually referring to.
The charge sheet here. Kindly come to here. The conclusions.
Conclusion, my lord.
Yeah. Kindly come to page 30.
Yes, my lord. This is the conclusion.
Yeah. After careful perusal of all documents as attached with the record of the proceeding of so and so, it is found the management side have observed due and necessary for holding this inquiry by giving reasonable opportunity to the charge sheeted worker to defend herself from the charges as alleged in the charge sheet. That from the evidence of the witnesses of the management side, particularly from evidence MW 6, 7, and 8, it is found that the worker, namely Sibani, had indeed restrained
My lord.
other workers of the estate from going to their duties on the morning of so and so near the gate of line number 8. The said act
Conduct.
and conduct of the worker amounts to riotous conduct, which is an offense of the gross misconduct.
My lord.
That's it.
Yes, sir. And this has been,
2 and 3 has not been proved.
this has been held to be perverse. So this is gone off the record stuff from the decisions I will show. Now, we have tendered evidence. In fact, if your lordship kindly see this paragraph, हमारे चित्र में close to very in that government police. Lord, before the your lordship, I will find at page 41 the written statement of the management. Written statement of the management,
Page 41.
page 41.
Yes.
Your lordship will kindly see paragraph 11.
Hmm.
That both the workmen participated in the respective inquiry, cross-examined the witnesses of the management, and also inter alia examined witnesses in defense. The inquiries were held in presence of two independent observers who were all along present during the inquiry. All the recordings of the proceedings were explained to the respective workmen in the language understood by them. Fair and reasonable opportunities were given to the concerned workmen before and during the inquiry in full compliance of the principles of natural justice and the established principles of law. So in my WS, I have relied on the domestic inquiry. Simultaneously, at page 39, if your lordship can be free.
Page?
Sorry, I'm sorry. Wait, I'm writing. Page 52. We have given we have adduced additional evidence. In fact, it starts from page 49. MW1 is the manager. I'm not troubling your lordship with that. Page 52 is one worker. Paragraph 3, if your lordship kindly see. On 4/9 so and so at about 7:30 AM, when I was proceeding to line number 8 from office, I saw Srimati Sibani and Mario. These are the two delinquent workmen restraining the workers from going to their workplace for duty. I saw so and so, so and so, so and so, and so and so, and some women workers who assembled near the gate of line number 8. I asked them as to why they had assembled there without reporting to their workplace. They told me that Mariam Sibani, her brother Martin, and some outsiders who were not workers of the estate restrained them from going to their workplace and have abused and threatened them with dire consequence. Then your lordship may come to page 54. This is another workman, my lord. This is MW3, paragraph 2, your lordship will see. On 4/9/2004 in the morning, while I, along with some other women workers, were proceeding to our work site, said Srimati so and so and so and so, the delinquent workmen, along with few outsiders and non-workers of the estate, restrained us and threatened us with dire consequences and abused us with slang words. They obstructed us near the gate of line number 8. Amongst the said non-workers, I saw Sri so-and-so Martin, who is the brother of Sibani. The women workers who were with me at the time were so-and-so and so-and-so. As the said Sibani and Mario, along with some outsiders, obstructed us from proceeding to our work site and threatened us using filthy words, we remained stranded near the gate till so-and-so reached the place. So-and-so is MW2. Then MW4, the same paragraph 2 again, that so-and-so threatened us with dire consequences, abused us with slang words, and also mentions about outsiders. So, my lord,
Show me your
See-
standing orders.
yes, I have the standing orders. Yes. Now, this has, because the word riot has to be understood in context of labor law. In fact, there is a case of this honorable court relying on this standing order where molesting a girl is said to be riot. In relying in this particular standing
Single bench, division bench.
division bench. Anyway, I'll place the case in paper. Here your lordship will find 10 acts or omissions which constitute misconduct.
Where? Then.
Towards
Yes.
the end, your lordship will find 10 clause 10, heading acts or omission which constitute misconduct. Has your lordship got that?
Hmm.
There, your lordship will find the following acts and omissions that constitute gross misconduct. One, willful, one may not be applicable, 2, 3, 4 not applicable. Your lordship may kindly come to 7, riotous conduct. Then 8, inciting others to disturbance or violence.
There is no inciting others. There are others.
Now, with dire concern-
Has any of your witnesses said that they have caused any disturbance in view of the incitement made by them?
That's because the manager reached, after the manager reached, MW2 reached and took control and
No. Did your witnesses say
Hello.
that they incited them? These two women incited these witnesses so that they could cause any violence? No.
that they have that.
So then the 8 does not come in.
Then 7, 7 is riotous conduct.
Yes, let's see what is right. Yes.
Well, that is not otherwise defined here.
Let's see what the
Yes.
division bench say, what is right. Yes. Now record this. Record nahi?
Before I
That's
take
all
the
okay.
lordships to the division, wait,
Where's the record? Record nahi?
what's called for an on 4/5/11 only the notice was issued. And then I don't think records have been called. It may not be relevant otherwise,
It is relevant, yes. Then what happened?
then we are actually will have to call.
Show me the right, yes,
Yes.
it is right.
But before I take any thought, but before I take your lordship to that decision. I'm sorry, my lord. I should have had them,
Where is the division bench judgment?
my lord.
Division bench judgment?
Okay, that seemed like. Division में judgment to दिया. This is 84 SSC online, Guwahati 93. This is of Justice T.S. Mishra and Justice Bob. Now, paragraph 10, your lordship will find, talks about the abusing evidence, where an employer holds no inquiry or the domestic inquiry is found to be vitiated by the tribunal, the employer has a right to justify the action of discharge or dismissal taken by him against the workman by adducing evidence before the tribunal. The workman would also have that same position. Then paragraph 13. The learned counsel for the petitioner submitted that the charge leveled against the petitioner was that he had attempted to molest one female worker named so-and-so, whereas before the industrial tribunal, the case of the management was that the petitioner had actually molested the girl and the industrial tribunal recorded a finding to this effect. The argument was that a new case was made out. The meaning of the word, that the rest may not be so important. The meaning of the molest is given, which says to trouble, disturb, annoy, or vex. Now, the meaning of molest is given in para 30. We do not find any merits in this contention. The meaning of the word molest as given in so-and-so is to meddle, hostility, or injuriously with person. Molest means to trouble, disturb, annoy, or vex. If the conduct of the offender is so lewd or obscene that the normal person would unhesitatingly be irritated by it, such conduct would fall within the definition of molestation. Now, if your lordship kindly come to paragraph 17. 17, they are referring to the standing order. Clause 10, then paragraph 18. Paragraph 18, if I may read. It would be noticed that riotous conduct constitutes gross misconduct. The meaning of the words riotous, as given in the concise Oxford Dictionary 6th edition, is marked by dissolute conduct. Dissolute means lax in morals. So riotous conduct means a conduct which is lax in morals. Conduct means personal behavior, deportment, mode of action, any positive or negative act. Riotous conduct therefore means personal behavior which is lax in morals. The phrase riotous conduct mentioned in clause 10(7) of the standing order would have hence include lewd, indecent, obscene, wanton behavior or act, positive or negative, which is lax in morals. Such conduct is gross misconduct under clause 10 of the standing order.
What
Any
do you
word,
say about Dumduma Tea Company?
my lord?
Dumduma Tea
Yes.
Company judgment,
My lord.
1962 LLJ 56, wherein says, when the standing order refers to riotous conduct and other subclauses refers to inciting others to disturbance or violence, then if an employee himself adopts violent attitude and assaults superior officers, he can be held to be guilty of riotous conduct in the context of the standing order. What do you think?
Riotous
Let
is
the
a
Supreme Court 5 judges bench.
it's a broad word, my lord. So
No, it can't be so much. What? You are asking these two persons, these two women out there, they are involved in riotous. It's too much.
my lord, your lordship will have
Go
to-
for minor punishment.
But before your lordships convert the punishment, may I just place few more decisions, my lord, because I am very well, my lord, I'll leave it to your lordships.
No, this is too much. I would have understood if there is one man involved, I would
The
have.
brother was there.
No, one workman involved who was a maid, I would have held it. It's something else. But there's no allegation which is proved out there in the domestic inquiry.
My lord, utmost respect, my lord.
Domestic
My
inquiry,
academic, my lord.
nothing which was,
Domestic.
because you have taken the action on the basis of the domestic inquiry.
Once that domestic inquiry is held to be covered, which has been done so by the labor court. That
Don't worry, that I'll take care of. The domestic inquiry, I'll hold it, that the labor court was wrong in holding it. But the question of, but the domestic inquiry has to be held to be riotous. The finding of riotous is bad.
My lord,
Inquiry,
at my lord, to the finding of riotous, the three workmen's evidence which are on record, my lord, they all say that these two lady workers, along with the brother and some outsiders, had come there to line number 8 and had obstructed and restrained them with dire consequences and filthy words not to go to their work. In this, during this process.
Mr. Goswami, you have to see these people were not represented at that point of time.
During.
Were not cross-examined. These people were not cross-examined. That is why I wanted to see the records.
Well, during that, well, the delinquent of.
Because Mr. Goswami, the thing is, the only other way is for sending the matter back to the tribunal. You see, the only other thing is to send the matter back to the tribunal, which I don't think there has to be a quietus to this industrial dispute.
Well, these delinquent officers have given their evidence.
No,
They have. I think they have.
then show me their cross-examination.
No, because then it was ex parte.
That is what I am saying.
Because they didn't.
They
appear.
did not.
They did not.
These workmen, the work,
See,
these people did not.
page 62 is the WS by the workmen. Page 64 are the DW1 and page 66 is DW2's evidence. But thereafter, I think it is mentioned in the award, they
I've
stopped
seen it.
appearing. If I am correct, my lord. Yes.
No good.
This court by order dated 3610 directed that the proceeding against the workmen will proceed on ex parte. And
I've seen
finally,
it.
on 170, I heard the ex parte argument.
It's taken. No, it's pending order.
Standing order, this one, It's a long,
I've seen it. It's a huge one. Where is it? Football.
because we have folded paper.
Okay. Okay. Now let us see your chart sheet also.
Page 23. You try to forcibly prevent the workers from their normal routine work. That is charge 1. Charge 2.
So when your charge as regards righteous,
Well, that is what I was trying to convey, my lord. The word righteous is very wide.
no.
Here, as seen by the division bench judgment, if an act which
No,
lack-
we will go by the constitution bench judgment. Dumduma. There has to be something by it.
Well, that perhaps that decision would be only in the facts and content, in that.
In your
my
case,
lord.
the judgment you are referring to is as regards the molestation of a woman,
Well, that.
of a
well,
girl by a
I'm
male.
Trying to impress your lordship.
This
that
is a judgment of the constitution.
in the context of labor jurisprudence,
This is labor. I am only saying about labor.
The word
Dumduma Tea
righteous-
Company is labor.
so, well, what I'm trying to submit is that the word righteous conduct appearing in clause 10 of standing order.
This is also standing orders.
Well, what I'm saying is it has to be interpreted in a broad way.
No.
Because
Why?
Ultimately, your lordship will
You
have
have not
see
put them to
today
charge.
if my employer,
Never
if
taken
my
any
workmen
responsibility.
are trying to incite the others or preventing others from working, and in this, during this process, valuable work time is you miss out. As an employer, I have to take a drastic step. Otherwise, a precedent. Otherwise, it will always.
Then why aren't you not putting it in your what you call this
Well,
these
orders
standing
is,
orders?
I think done by the Assam. And gardens do not have their. This is standing orders for tea state in Assam and the membership of the Assam and so of the Indian Tea Association. So the association framed these guidelines, my lord, and it is there.
Let's see how the trial was. Labor court took into.
Yes, my lord.
Kindly come to page 75.
Yes, my lord. My lord, I'll start from 73. After perusing,
These are not necessary.
top of page 73, the first paragraph, your lordship will kindly see the last three sentences. I have also perused the evidence of inquiry officer, Shri so and so, and it is apparently seen that he did the inquiry against the workmen following the principles of natural justice and the procedure of the law. Now, your lordship will come to 75. Your lordship will kindly see from evidence of, my lord. May I please 75, my lord?
Yes, I'm looking.
The
Kindly come to page 74.
75,
74,
24. Yes, my lord.
paragraph 7.
Paragraph.
7.
Yes. After perusing the inquiry report, Exhibit O, it appears to me that before the inquiry officer, the management side witnessed MW1 so-and-so states before the inquiry officer that both the delinquent workmen asked her not to go to work. MW2 states before inquiry officer that on a particular day in the month of September, the delinquent workmen obstructed them near the gate of line number 8 and asked them not to go their work. And so the workers stayed there for a while, and soon after they went to attend their works on being scolded by Augustine. MW3, by deposing evidence before the inquiry officer, states that on 4/9/2004 at morning he found some workers were waiting near the gate number 8, who told him that the delinquent workmen obstructed them and asked them not to go to work. And then he scolded the workers and asked them to go to work. And the workers went to the work. MW4 so-and-so deposed evidence before the inquiry officer, but does not state anything about happening in the gate number 8 at morning. MW5 deposing evidence before the inquiry officer states that on so-and-so at morning, while he went to line number 8, seeing some workers were gathered there, so-and-so reported him that the delinquent workmen obstructed those workers from attending their duties. But those workers later on went to work on persuasion. MW6 giving evidence before the inquiry officer states that on 4/9/2004 at morning, he went to line number 8 of the garden and found some workers assembled near gate number 8. And then he saw the delinquent workmen were slowly leaving the place towards their quarters. And then the workers informed him that they were obstructed by said delinquent workmen. From evidence of PW1, it is seen that the delinquent workmen had only asked the workers, including herself, not to go to the work. This witness does not state that they have been threatened of dire consequences by the delinquent workmen if they would go to work. MW2 also states that the delinquent workmen had only asked them not to go to their work. This witness also does not state that the delinquent workmen applied force to restrain them from going to work or threaten them. From evidence of MW3, it is also seen that he does not state that the delinquent workmen applied force to restrain the workmen from attending the work or threaten the work. MW4 is not eyewitness of alleged occurrence. Likewise, MW5 is not eyewitness of the said alleged occurrence. MW6 does not state that the delinquent workmen were applying force, restraining the workers from attending the work or threatening the workers. Thus, it is seen that the delinquent workmen had not applied any force in restraining the workers or assembled in gate number 8 at morning from attending their work, nor threatened workers of dire consequences, but they just asked them not to attend their duty, and thereafter they left to their quarters. From evidence of the witnesses examined by the delinquent workmen before the inquiry officer, it is seen that so-and-so DW1, DW2, DW3, and Shri so-and-so states that they had not seen any occurrence alleged by the management side. To an act to be a riotous act, there must be application of force against the victim persons or resorting to violence against the victims. The meaning of riotous act as per Oxford Advanced Learners Dictionary is the action done must be noisy and or violent, especially in the public place. The meaning of the riot as per such dictionary is that riot is a situation in which a group of people behaved in a violent way in a public place, often as protest. Thus, it is clear that the element of violence, right, definition later on. The element of violence, of course, must be found in the action of the doer to call that act as a riotous act. In our present case, it is clear that the delinquent workman just only asked the workmen not to attend the works on that day, as Atsa called upon Ban in the garden on that day. In this case, this court must base on the evidence recorded by the inquiry officer, as because the inquiry is found fair, and hence the evidence given before the court by the witness did not be considered. Second ground is that the inquiry report is based on evidence recorded by the inquiry officer, and dismissal was done on the basis of the inquiry report submitted by the inquiry officer. And for that reason, this court must base its decision on the evidence recorded by the inquiry officer. The inquiry officer's MW6 was cross-examined by the workman's side before this court. Your lordship will find that the cross-examination was done. Was cross-examined by the workman's side.
Before the inquiry officer. Oh,
Before
here.
this court.
Ah.
The inquiry officer was cross-examined by the workman's side before this court. That means after the stage of cross-examination, they must have stopped appearing, and that is how the hearing went ex parte. And during cross-examination, they put a suggestion to him that his decision was perverse, which he denies. The very act of putting such suggestion amounts to claiming the decision of the inquiry officer a perverse decision, which means that without basing on evidence, the inquiry officer held that the delinquent workman committed riotous act. It is already found that on 4/9/2004 at morning, the delinquent workman did not indulge in any riotous act at gate number 8, affecting the workers assembled there. Therefore, I hold the decision of the inquiry officer so and so that the delinquent workman on 4/9/2004 at morning near gate number 8 indulged in a riotous act, which is a misconduct as per clause 10A7 of standing orders of Bihaliti estate, is a perverse decision. Secondly, I also hold that the action of conduct of the workman on that day is not covered in any of the provisions of clause 10, and hence the act of dismissing both the delinquent workmen, namely so and so from service, is an illegal act, and hence the dismissal order issued against them by the management of Bihaliti estate, vide letter dated so and so, are illegal orders and were passed violating the provision of section 25F of ID Act, and are hence liable to be quashed, and the dismissal order are liable to be quashed. The workmen are entitled to reinstate.
Then right?
No evidence is adduced by the management that the delinquent workmen have taken some alternative income source after date of dismissal from the service of the garden. On the other hand, the delinquent workmen also in their written statement does not specifically state that they remain unemployed after dismissal. So it must be presumed that the delinquent workmen must have resumed some sort of income sources, although it may not be gainful income source. Because of what has been discussed and analyzed above, I am of opinion that the management has no prima facie case against the delinquent workmen, but they illegally dismissed.
Mr. Goswami, these persons whose evidence have been discussed, this is the same evidence which have been given before the labor court also. What is the difference?
Well,
What else would have made the difference?
to answer your lordship's query, may I just refer to a few decisions, my lord,
For what?
to answer to your lordship's query?
No,
Because,
no, I am only asking, this is on facts.
my lord, because,
There is a case, no, why I'm saying,
my lord,
the evidence of these very witnesses were given out there in the.
Yes, yes.
Professor.
yes,
They did not say different, anything different. The
yes.
same thing.
Yes.
They all of these witnesses except Dilip Kumar Bora. Dilip Kumar Bora doesn't come
Inquiry
into the
officer.
picture because he was a manager who came late for all.
No, Dilip Kumar Bora is the inquiry officer.
No, the
manager
other one,
was
Dhruva
Augustine.
Kumar Swan.
Augustine.
No, this person, Dhruva Kumar Swan. Dhruva Guha Sarkar. The evidence in affidavit of management witness number 1.
My lord, he is
He's
the
only
manager.
the manager. So that makes no sense.
Yes,
Other who were there, their evidence were duly given out there before the inquiry officer.
my lord.
It is the same evidence which is being given here also. It's okay. Now the same evidence is being discussed. So how does it make any difference?
Lord, with utmost respect, my lord, at the time of abusing evidence before the Learned Labor Court, these witnesses have merely said restrained and obstructed. They did not detail out how this was done. That has been done before the Labor Court, where they have elaborated it, how they have been obstructed and restrained from not going to their work. They have said it categorically there that along with these two officers.
So there you admit
My lord,
that they have improved theirs.
my lord, my lord, this is not a criminal trial, my lord. There is.
No, I'm asking you, are you saying that they have improved?
Well, that is that is why I said I will take your lordships to the decisions, because
Yes, what is that
you
decision?
will kindly see that before ultimately in the inquiry report, they may not have said few things. But now the law is giving a right to the management to come and prove it by fresh evidence. And we have
No, I'm not on that. Let us assume that they have proved.
Yes.
What they have stated also
Yes.
is the same thing which is being stated by those
My
persons.
lord, now there are two things, my lord. If your lordship is of the
Have
opinion,
It is out here in these evidence, then look here, these people manhandled me. These people had,
manhandling is not
Then-
there. Manhandling is not
it
there.
is the same thing. They have
Yes.
stated categorically that these person along with this person were very much there because they also, if you
They
see their evidence, that
obstructed,
paragraph number
restrained
3.
with dire consequences and filthy words. This is with it. This is there.
No, but everybody in their evidence before this, because you are relying on the inquiry report, so then,
My lord, I was relying till,
no, you can't say that you are not.
my lord, your lordships will have to appreciate my.
You have relied upon the inquiry report for the purpose of dismissing the persons.
Very well, my lord. Now, once the labor court comes to a conclusion that that inquiry has gone, everything goes.
No, the labor court did not go, you see, those judgments which you are referring to, Delhi cloth mills and everything, all the judgments are pertaining to fairness of the procedure of the labor court. This is not the same. Here the
For a
court,
moment,
here
your
these
lordship, kindly
persons.
have writs theatre, my lord, for my.
Yes, tell me, what does it say?
This is reported in AI 1963 Supreme Court 295.
Yes, what does it say?
Separate to like. I will start from
Yes,
paragraph
thank
8, my lord.
Yes, tell me.
Has your lordship got a copy?
Yes.
Yes. The first point, from the end, your lordship will find fifth line from the bottom. It is well settled that if an employer serves the relevant charge or charges on his employee and holds a proper and fair inquiry, it would be open to him to act upon the report submitted to him by the inquiry officer and to dismiss the employee concerned. If the inquiry has been properly held, the order of dismissal passed against the employee as a result of such an inquiry can be challenged if it is shown that the conclusion reached at the departmental inquiry were perverse, or the impugned dismissal is vindictive or malified and amounts to an unfair labor practice. In such an inquiry before the tribunal, it is not open to the tribunal to sit and appeal over the findings recorded at the domestic inquiry. This court has held that when a proper inquiry has been held, it would be open to the inquiry officer holding the domestic inquiry to deal with the matter on the merits bona fide and come to his own conclusion. It has, next paragraph, my lord. It has also been held that if it appears that the departmental inquiry held by the employer is not fair in the sense that the proper charge has not been served on the employee or proper or full opportunity had not been given to the employee to meet the charge, or the inquiry has been affected by other grave irregularities vitiating it, then the position would be that the tribunal would be entitled to deal with the merits of the dispute as to the dismissal of the employee for itself. Then your lordship will kindly see the same result follows if no inquiry has been held at all. In other words, where the tribunal is dealing with a dispute relating to the dismissal of an industrial employee, if it is satisfied that no inquiry has been held or the inquiry which has been held is not proper or fair, or that the findings recorded by the inquiry officer are perverse. The whole issue is at large before the tribunal. This position also is well settled. Then paragraph 10, in regard to cases falling under this last category of cases, it is however open to the employer to adduce additional evidence and satisfy the tribunal that the dismissal of the employee concerned is justified. And in such case, the tribunal would give opportunity to the employer to lead such evidence, would give an opportunity to the employee to meet the evidence and deal with the dispute between the parties in the light of the whole of the evidence thus adduced before it. There can be little doubt even about that position. Now, this was done. Here, both parties had adduced evidence, they have and they have cross-examined.
No. The workman did not adduce evidence.
So it will adduce evidence by
No,
that in the
where is it?
report.
Where is it? You have not enclosed it.
Page 64, DW1, page 66, DW2.
Where?
Page,
Page?
Page 62 is the workman's WS.
Then
Then page 64,
people is what?
the delinquent witness number 1. Then page 66 is DW2. They have adduced evidence before the labor court.
Now, did you cross-examine?
I'm not sure whether.
You have not cross-examined, then it is proved. You have not tested the witness.
I'm not sure from which.
No, Mr.
section of
Goswami,
hearing. Let me. not
Others,
do that.
these judgments also, see, what prejudice you are saying? The court did not. It is a question of interpretation as to whether the conduct was righteous. The inquiry officer, the persons who have adduced evidence before on behalf of the management, we are not concerned with that manager because he was not a person to that. We are only concerned as to whether the act amounted to righteous. I would not take into account your submission to that effect that they improved because that doesn't hold.
But I am not
That's totally
saying they have
misconceived.
improved, my lord.
Because that is totally misconceived. Because the question of improving at a later stage does not arise. The evidence has to be what it is. You can't improve on your evidence.
I am not saying it about improvement, your lordship will kindly.
It is a question you are saying. You only submitted about the improvement.
My lord, I said elaborated. My lord, if they, my lord, otherwise.
Elaborated.
Your lordship will.
The
kindly-
very evidence categorically stated that when the workman, Augustine something, he went out there and told them, what are you doing? All these people went to their to work.
To what? To what?
So that is an admitted fact which is already there,
Yes,
which
my lord,
however,
stand has
that
not
aspect
been,
of the
taken.
matter, therefore I'm saying,
No.
however, that aspect of the matter, these people have not stated in their evidence.
Huh?
That aspect of the matter, these people have not stated in their evidence.
Before the labor court.
Yes.
So they have said, then Augustine came. That is said in the next paragraph. That is there.
Yes.
It is there, it is there. Well, there is no contradiction. Paragraph. What is it? 52, no? I'm sorry, I didn't place the entire evidence because I thought it will not be relevant, but your lordship may kindly come back to page 52. 52 is Augustine, so let us skip that. 53, 54. 54, your lordship will kindly see. Paragraph 3. During this time, we were standing near the gate of line number 8 for the above acts and conduct of said Shivani and Mariam with their companions, Sri Augustine, with their companions. Sri Augustine in came to the place and we narrated these incidents to him. At that time, Shivani, Mariam and their associates left the place. Augustine told us to go to our work site without paying any heed to Shivani and Mariam. We therefore went to our work site for our duties. But in the process, we lost considerable working time, that too during the peak plucking season. As we were late in reporting for work, we did not receive full wages from the management on that day. We suffered due to the irresponsible act of Shivani and Mario, who stopped us from going to our work site. Then PW4, again paragraph 3, same thing. They are saying the same thing. There is no improvement. I'm not.
So if they are saying the same thing has been taken into account.
Not this, my lord. The learned labor court has only taken into account the evidence adduced before the inquiry officer and came to a
And
finding
that is the same thing which these
of
people
the
have
inquiry
stated.
officer is perverse.
Perversity is only on the question of the interpretation as to whether charge 1 is righteous, not on other aspects.
I would understand if it is in terms of that in case there is no evidence that what is perversity is decided in Delhi cloth case at paragraph 43, 44 and 45. And it says that in case there is no evidence, that is perversity.
Absolutely, there is no evidence.
The
where
learned
is the
inquiry
evidence of
the
physical
labor
assault?
court has, by adducing the evidence, by perusing the evidence of the adduced before the inquiry officer, came to a finding, no, there is no evidence.
No. Where the question is whether there was evidence for the purpose of holding the charge of righteous.
Be
We are
it,
not concerned with another thing. Now there was the labor court came to a finding that there was no evidence on the question of righteous.
very well, my lord. No, very good, no? Very good, my lord. But, very well, my lord. Just for a moment, that Dumduma's case that your lordship is referring, if I may just read para 11 once again, my lord. I'm sure your lordship will take your time. Yeah, he will look. But I may be wrong in my perception, but let me just try and impress your lordship on this. The lordship will kindly see paragraph 11. There is only one point which may be incidentally mentioned before we part with this case. Mr. Agarwal attempted to argue that the conduct attributed to respondent 2 did not amount to misconduct under section 10A7 of the standing orders. Clause 10A7 refers to riotous conduct, and Mr. Agarwal contends that attacking so-and-so does not constitute misconduct under the said clause. So the argument was that if you are attacking your superior, that is not riotous. This contention has never been taken before, not before Mr. Black, nor before the Industrial Tribunal, nor in the statement of the case before us. Besides, having regard to the other cognate items in Standing Order 10, it is impossible to hold that riotous conduct does not include the assault in question. It says does not include the assault in question. Clause 10A8 refers to inciting others to disturbance or violence, which means that if an employee incites another employee to cause disturbance or to adopt violence, that would fall under clause 10A8. If that is so, if an employee who himself adopts violent attitude and assaults his superior officer can, in the context of standing orders, be treated as guilty of riotous conduct. Therefore, there is no substance in the argument that clause 10A7 does not
There
imply.
has to be some physical thing.
Lord, here they are saying assaulting a superior will include, but that does not exclude all others. Well, it doesn't say that riotous conduct will only include if there is a violence. It does not say that riotous conduct.
Then where is the other judgment to the show that the riotous conduct?
The division bench
any other would be a riotous
Well,
conduct.
I have given.
You see,
Now,
if that be so,
yes.
you have given that judgment of Justice Mishra.
Yes.
Let us see what does he say. In
Yes.
his judgment, yes, here he says that riotous constitutes so and so. Riotous conduct therefore means personal behavior which is lax in morals.
Yes.
What do you mean by lax in morals?
But if some low, we have that.
In low in morals.
Yes, yes.
Okay.
That is also there in.
Now kindly come to your standing orders.
Yes, my lord.
Kindly come to your standing orders.
Yes, yes.
Kindly come to drunkenness while at work.
Yes. Yes, my lord.
Then isn't that lack in morals?
Dissolute, if it is the behavior is dissolute, that will also.
No, no,
not
I'm
be the right.
saying drunkenness.
Drunkenness, that's
While at
specifically
work.
given it.
No, wouldn't that be lax in morals?
My lord, with utmost respect, my lord. They have specifically given the spelled out that these are gross misconduct. Now, they have specifically made drunkenness as a misconduct. Then they have the riotous conduct. Now here, what is riotous conduct is not defined. So therefore, we will have to go to the meaning of riotous conduct. Now there can be various situations.
Then what do you say about this other?
Look, what I'm trying.
Quarreling.
Yes, but
No, what do you say? Quarreling, fighting, or
Well,
causing
these are-
disturbance
these are-
prejudicial to good order.
these are, but they
No,
have.
that is with a fine.
Yes. Well, now if your lordship holds that because these are spelled out and then riotous conduct is just the term used, so it will, then what will that mean? Now, to understand what riotous conduct, what conduct would be riotous, we have to go to the dictionary meaning.
Yes.
We have to go to the dictionary meaning. Now, in the division bench judgment, they have gone to the dictionary
But
meaning.
if we go by the lax in
My
morals,
lord.
then why not why this action wouldn't come within the ambit of quarreling,
But
fighting, or
molestation is
causing
also not
disturbance?
Well, molestation is also not spelled, but
No, no, no.
molestation has been held.
You see, molestation has a physical act. Kindly come to 10B5.
Yeah. Yes, my lord.
10B5.
Yes. Sir. Yes, minor. The following acts and omissions shall constitute misconduct, for which offenses the manager reserve the right to fine. Now here, gross misconduct as defined in Standing Order 10A, so those will also come. Committing an indecency or an act prejudicial to public health or on or near the road, work site, or building within the plantation. Neglect or default causing the.
Now we are concerned with 5.
Yes. Your lordship is concerned with 5. Quarreling, fighting, or causing disturbance prejudicial to good order.
So wouldn't this come within the ambit of that?
Your lordship is right. Your lordship may convert it to this and.
Because you see, these industrial disputes have to be brought to a quietus.
My lord,
There has to be a quietus to these industrial disputes.
my lord.
You can't keep on pending out here, again remanding it back
Sir,
out there.
remand does not serve any purpose. It's a very old matter.
It's a very old manner, and initially this has happened in 2004.
Your
We are in
lordship is right,
2023.
sir, because it also says quarreling, fighting, or causing disturbance prejudicial to good order. So here
This
is
is
the
what
case,
has happened.
they have caused disturbance to the good order for which they were stopped for some time. Yes?
So therefore, if that be so, the punishment could have been this for which they could have been imposed a fine. And they are getting the last drawn wages. Yes, please. Tell me, what do you have to say now? You were asking for adjournment, tell me.
Yes, sir.
As I didn't see you, because of that, I had to argue for you all this while. Yes, tell me now. As I now see, tell me, why didn't you cross-examine?
My lord.
Why didn't you cross-examine these witnesses?
In the labor code, man.
Yes,
Actually, whatever Miller in the labor code, the advocate engaged in the labor code, during the pendency of the case, he expired. You know.
Hmm.
That was, it is an expiry order actually, in fact.
an party can be passed.
Yeah.
The labor court has to only pass an order to the
Yeah.
effect that the reference has been given, the reference has to be answered. You can't dismiss for default a reference.
Yeah.
But the reference can be answered, the reference has been answered.
That is why they were not cross-examination. Or the Indian advocate was not there. Vendon Miller, our case is very simple, Miller. There are 3 charges. 2 charges, the inquiry officer himself ignored. On number, the 1 charge is a very trivial charge. That is, it is not a case of dismissal. And section 11A clearly empowered the labor code to interfere with the punishment.
Mr. Goswami,
My lord,
you kindly come to page 30 again,
page 40.
30.
Yes, my lord.
See, these are the 3 charges
Yes.
which have been proved. Number 2 is said to be proved, where he said to be a righteous conduct. That is a different name. But see number 3. 3 comes within the ambit of
My lord.
10A8.
Yes, in fact, I thought that also. Yes,
So charge number 2 has not been proved,
Yes.
which is 10A8.
yes.
Then other is third charge is 10A1 and 10A10.
Yes,
So that has not been proved.
yes.
And if you see number 2,
Hmm.
that from the evidence of the witnesses of the management side, particularly from the evidence of MW 6, 7, and 8, it is found that the workers so-and-so had restrained other workers of the year from going to their duty on the morning at near late number so-and-so. There's nothing more than that. So the learned labor court held that it couldn't have been a case of righteous, and as such it is perverse.
Yes.
But it may be a case of
In
this one,
disturbing,
10B, right?
disturbing.
Because that has been proved. I can't help you. You have not cross-examined. So we interfere with the labor court's order only to that extent, and thereby say that you will be entitled to all this, but there will be some fine. That's all.
Fair enough.
That is the only way. Or go for another 10 years before the trial. And then again come and file another 11 years. Chalo.
No, Miller, labor court can intervene, Miller, in the quantum of punishment under section 11A.
Even this court can.
Understood, but the fact which got proved, one fact is proved. The labor court interfered and said that it couldn't have been righteous. And as such, the termination was bad. That is what has been held.
Yes.
But from the evidence, the labor court did not take into consideration one aspect of the matter, that there was something which is already there. There was no cross-examination, nothing, and that has already been proved to that effect. So under such circumstances, there is a case which will come under 10B5, where the punishment would be only fine. So minimum fine will be imposed and matter will be over. I think this will bring a quietus to the industrial dispute,
Yes.
isn't it? Okay, now take a seat. The incident repetition has been filed challenging the award dated 6/7/2010, passed in reference case number 5/2008, whereby the Learned Labor Court directed that the workmen who were dismissed by the petitioner T state be reinstated and paid 50% of the back wages was the facts involved in the instant proceedings is that on 4/9/2004 at 7:45 a.m. to 9 p.m., there was an obstruction being caused by the delinquent workmen for which the other workmen could not attend their duties within time. It is under such circumstances on 8/11/2004, the manager of the petitioner T state issued two separate charge sheets against the two delinquent workmen, namely Shibani Lagun and what is the other name? Mariam Lagun. It appears that pursuant to the said charge sheet being issued, an inquiry officer was appointed to inquire into the charges leveled against the two delinquent workmen. At this stage, it is relevant to take note of that the three charges that both the delinquent workmen were charged with the following charges. Number one, the delinquent workmen tried to forcibly prevent the workers from their normal routine work. Number two, the delinquent workmen tried to incite the workers, seriously damaging the peace and order in the division. And number three, it was reported by the line chowkidar that the delinquent workmen were entertaining outsiders in the company quarters without any prior permission of the management. During the said domestic inquiry, as many as 9 witnesses adduced evidence on behalf of the management, and on behalf of the delinquent workmen, 4 witnesses adduced evidence. Two separate domestic inquiry reports were submitted by the inquiry officer, the contents of which are parameterious. From a perusal of the said domestic inquiry reports, both dated 18th of February 2005 it is seen that charge number 1 was held to be proved, whereas the charge number 2 and 3 were held not to be proved. As regards charge number 1, the learned inquiry officer held that from the evidence of the management witnesses, it was found that the workers, the delinquent workmen, restrained other workers of the estate from going to their duties on the morning of 4/9/2004 near the gate of line number 8 of Bihali division. On the basis of that, the learned inquiry officer came to a finding that the conduct of the delinquent workmen amounted to riotous conduct, which is an offense of grave, gross misconduct. Pursuant to the said inquiry report, the both the delinquent workmen were dismissed from service by similar orders of dismissal dated 27/5/2005. Pursuant thereto, the government of Assam by notification number GLR 117/2005/15 -A dated 18/2/2008 made a reference in terms with section 10 or 10A. Section 10 of the Industrial Disputes Act 1947 by referring the following, by making the following reference, which are enumerated hereunder, page 41 of Pavode 1, 2, and 3. Because it appears on record that the management, that the petitioner filed their written statement as well as additional written statement, as well as full stop, that the on behalf of the both the delinquent workmen, the respondent number 2 hearing submitted the written statement, only one written statement, no?
Yes.
Written statement. It further appears that the management adduced evidence and on behalf of the delinquent on behalf of the respondent number 2, the delinquent workmen had also adduced evidence. The Learning Labor Court, by an order dated, no, it is relevant to take note of that during the midst of the proceedings before the Learned Labor Court, the respondent number 2 did not further participate in the said proceedings, as can be seen from a perusal of the award itself. The Learned Labor Court, by the ex parte award dated 6/7/2010, decided answered the reference by holding that the dismissal of the two delinquent employees, workmen by the petitioner management was illegal, and that the two delinquent employee be reinstated by making payment of 50% of the back wages. It further appears that the said award dated 6/7/2010 was published on 19/1/2011. It is under such circumstances that the petitioner being agreed have approached this court.
কোনটি মেটা আছে দাদা এটা কিবা এটা করতে আপনি ব্যাংক স্টেটমেন্ট এর ম্যাটার আছে নাকি আপনি প্রপোজাল কম্পিউটার করতে বলেছেন নিয়ে দিতে পারবেন কথা না জানো মানে কম্পিউটার একটু কিবা রিসিপ্ট সমস্যাৰ ফলে দিয়া মুখ ফলে কিবা তেনেকুৱা কিবা আছে নেকি কিবা কি আপুনি তেনেকুৱা খবৰ দিলে 417 বুলি কৈছে মানে আজি ওল্ড পেন্ডিং আছে কি জানো ওকে ঠিক আছে কেমন কোয়া তুমি না এতিয়া আসল আসল
In the backdrop of the above, this court, by an order dated 4/5/2011, had issued notice and in the interim state the operation of the award dated 6/7/2010 passed in reference case number 5/2008. Like it further appears on record that during the pendency of the instant writ petition, a miscellaneous application being MC 3239/2012 was filed by the delinquent employee, a workman, under section 17B of the Industrial Disputes Act 1947. This court, by an order dated 8/1/2013, disposed of the said application, thereby directing that the delinquent workman be paid the last from wages. In the backdrop of the above, let this court therefore take into consideration the case of the petitioner, the contentions, raised by the learned counsels for the parties. Mr. K. Goswami, the learned senior counsel, have essayed the impugned award dated 6/7/2010 by submitting that the learned labor court completely erred in law after holding that the decision of the inquiry officer to be perverse, not to discuss the evidence and decide the reference on merits. The learned senior counsel has drawn the attention of this court to the judgment of the Supreme Court in the case of Management of Reeds Theatre (Private Limited) Delhi versus Workman, reported in AIR 1963 SC 295. And referred to paragraph 8, 9, and 10 of the said judgment. To canvass the point, that once the learned labor court had held that the inquiry officer's findings were perverse, the whole issue was at large before the tribunal. And as such, the learned labor court had abdicated its duty in not deciding the reference on merits. The learned senior counsel further has drawn the attention of this court the learned senior counsel has further submitted that the learned labor court also had erred in law in coming to a finding that the findings of the learned and of the domestic learned inquiry officer in the domestic inquiry was perverse as regard charge number 1, wherein it was held that the delinquent employee were guilty of righteous conduct. The learned senior counsel submitted that righteous conduct, which is a great misconduct in terms with the standing order, more particularly clause 710A7, means personal behavior which is lax in morals. The learned senior counsel therefore submitted that in view of the fact that the delinquent employee were guilty of righteous behavior conduct, which was a great misconduct in terms with the standing order, there was no infirmity on the part of the respondent, on the part of the petitioner T state, on the part of the management of the petitioner T state, to dismiss the delinquent workman, and as such the reference ought to have been decided in favor of the management. In that regard, the learned counsel has further drawn the attention of this court to a judgment of this court in the case of K.M. Dave versus Presiding Officer Industrial Tribunal Dibrugarh and others, reported in 1984 SCC Online GAU 93. Anything else? These are the two. Yes. You have to say anything? What do you want to say? You won't say. Mr. Estes, the learned counsel appearing on behalf of the respondent number 2, had on the other hand submitted that the charge so proved before the domestic inquiry cannot under any stretch of imagination be said to be a righteous conduct within the ambit of the standing order, clause 10 bracket 7, 10A7 of the standing orders. The learned counsel further submitted that the perusal of the impugned award would also show that the evidence of the on the part of the management, which was tendered before the learned labor court, was the same evidence which was submitted before the domestic inquiry, and the same was discussed in detail by the learned labor court, and on the basis of that have come to an opinion that the act had come to an opinion that the act complained of would not come within the ambit of righteous conduct, thereby entailing grave misconduct within the ambit of the standing orders. The learned counsel further submitted that even assuming the entire evidence on record, as well as the domestic inquiry to be correct, it may at best be a case of causing disturbance prejudicial to good order, which is a minor punishment in terms with clause 10B5 of the standing orders. This court, next, have perused the materials on record and have given an anxious consideration to the matter, have perused the materials on record and have taken into account the respective contentions from a perusal of the impugned award. It would be seen that the learned labor court had categorically come to a finding that the domestic inquiry so carried out was carried out in a fair manner. The learned labor court had only held that the findings arrived at in respect of charge number 1 was perverse, as the attending facts which came into light on the basis of the evidence on record did not constitute righteous conduct, and as such came to a finding that the decision oblique the reports was submitted by the inquiry officer in respect to charge number 1 was perverse. In that view of the matter, the question therefore arises for consideration before this court is as to whether the misconduct alleged against the delinquent employee and workman would come within the ambit of a righteous conduct, which amounts to grave misconduct in terms with clause 10A7 of the standing orders. At this stage, now before further proceeding, this court also finds it relevant to take note of the first submission of the learned senior counsel appearing on behalf of the petitioner. Whereby it was submitted that the petition, that the learned labor court after holding that the domestic and findings of the domestic inquiry to be perverse, ought to have decided the reference on merits and there was no discussion on the basis of the evidence which was tendered before the learned labor court. This submission, in the opinion of this court, though looks attractive at the first blush, but on an intricate analysis of the impugned award would show that the evidence which was tendered before the learned labor court was the same evidence. The evidence as regards the incident on 4/9/2004, which was tendered before the learned labor court, was the same evidence which was also tendered before the tendered in the domestic inquiry. And the learned labor court in paragraph number 7 had in great detail discussed the entire evidence. This court further finds it relevant to observe that it is on the basis of the discussion of the same evidence, said evidence, the learned labor court came to an opinion that the misconduct alleged would not come within the ambit of righteous conduct. Therefore, the entire issue involved in the instant proceedings is as to whether the misconduct so alleged amounts to righteous misconduct, righteous conduct. In Black's Law Dictionary, 11th edition, the term riot have been defined as an assemblage, ASSEMBLAGE, of 3 or more persons in a public place taking concerted action in a turbulent and disorderly manner for a common purpose, bracket, regardless of lawfulness of that purpose. It has further been mentioned, it has been further defined that an unlawful disturbance of peace by an assemblage of usually 3 or more persons acting with a common purpose in a violent or tumultuous, TUMULTOUS, manner that threatens or terrorizes the public or an institution. In Stroud's Judicial Dictionary of Words and Phrases, seventh edition, the term riot as interpreted in Field versus Receiver for Metropolitan Police District, reported in 1907, 2 KB 853. It was held that to constitute riot, there is a requirement of 5 necessary elements. 1, 3 persons at least. 2, common purpose. 3, execution or inception of common purpose. 4, an intent to help one another by force, if necessary, against any person who may oppose them in the execution of their common purpose. 5, force or violence displayed in such a manner as to alarm at least one person of reasonable firmness and courage. This interpretation, so given in the case of Field, Supra, Amen. In the same dictionary, in the same Stroud's Judicial Dictionary, the term righteously, RIOTOUSLY, have also been defined In Wharton's Law Lexicon, 16th edition, right have also been defined as a tumultuous disturbance of peace by 3 persons or more assembling of their own authority with an intent mutually to assist one another against any who shall oppose them in the execution of some enterprise of a private nature, and afterwards actually executing the same in a violent and turbulent manner to the terror of the people, whether the act intended were itself lawful or unlawful. In the major law lexicon by P. Ramnatha Iyer, 4th edition, the term right have been extensively discussed. Referring to Edward Jenks, Jenks, the Book of English Law, the right was defined as an unlawful assembly, bracket, that is, an assembly come together in pursuance of an unlawful purpose, bracket close, consisting of at least 3 persons, which have begun to create peace, breach of peace. In the said dictionary, in the said law lexicon, riotous and disorderly behavior have also been defined. It has been stated that the expression riotous and disorderly behavior, riotous and disorderly inverted commas, is very wide in its scope It covers acts of committing nuisance on one hand and acts of assaults and riots on others, fighting, assaulting, abusing, drunkenness, etc. on the premises of an establishment during duty hours are some of the instances of riotous or disorderly behavior. Therefore, taking into account the above definitions, and more particularly, when the term righteous is an adjective of the word riot, this court is of the opinion that to constitute a righteous conduct, the elements of riot as laid down by the as laid down in the case of field supra has to be established This court also finds it relevant at this stage to take note of the judgment of the court in the case of K.M. Deb, Supra, wherein it has been mentioned that righteous conduct means personal behavior which is lax in morals. it may be relevant to take note of that this court while dealing with the term righteous conduct in the judgment in KM Dev had referred to the concise Oxford Dictionary for the term righteous. Concise Oxford Dictionary for finding out the meaning of the word righteous, wherein it was mentioned that the word righteous means marked by dissolute conduct. With due respect, the word dissolute, the learned court, this court defined it as lax in morals. Whereas the actual meaning of the word dissolute is lacking restraint. It is under such circumstances, this court therefore is of the opinion that in order to constitute a righteous conduct, the assembly of persons, there has to be an assembly of persons of more than three persons. There should be an assembly of three or more persons with a common purpose, and there has to be a force or violence displayed in such a manner as to alarm at least one person of the reasonable firmness and courage. This court further finds it relevant to take note of that the Lowland Labour Court have also while taking the meaning of righteous act, I have borrowed the meaning of the term righteous act from the Oxford Advanced Learners Dictionary, wherein it has been mentioned that the action done must be noisy and or violent, especially in public place. The same definition can also be found from the Black's Law Dictionary, as already referred to here in above. Now, coming to the facts involved in the instant case. And the evidence so discussed in paragraph number 7 of the impunity award it would be seen that the delinquent employee who are two women workmen employee, no, the delinquent workmen, who are two women workmen had tried to dissuade their fellow workmen from attending the duties. However, when Sri Augustine A.I.N.D., Augustine Aind, the management witness number 2 came to learn about the same, and he intervened. The workman, the other workman, thereupon went to their place of work and started their duties. It would also be seen from the report of the domestic inquiry report, wherein charge number 1 is wherein the evidence, where the evidence of the witnesses were appreciated and documents were discussed. It was only observed that the delinquent employee workman had obstructed other workmen of the estate from going to their duties on the morning of 4/9/2004 near the gate of line number 8 of Bihali division. There was no discussion, and there is no materials on record to show that any force or violence was displayed in such a manner to alarm the other workmen by the delinquent workmen. Under such circumstances, this court is therefore of the opinion that the learned labor court had therefore rightly held that the findings so arrived at by the learned labor, by the domestic office, by the inquiry officer in the domestic inquiry, that the act on the part of the delinquent employee, a workman, amounted to righteous conduct was perverse. This court therefore is of the opinion that no interference therefore is called for. As regards the findings so arrived at by the learned labor court, holding that the decision of the inquiry officer, the findings of the inquiry officer be perverse for holding perverse as regards chart number 1. Under such circumstances, this court is therefore of the opinion. Another very vital aspect of the matter which also needs to be taken note of that the learned labor court, though had come to a finding that it was not a righteous conduct on the part of the delinquent employee, a workman, but did not further go to decide the reference in total, the reference as insofar as the other two did not decide. Point number 2 and 3 of the said reference so made by the government of Assam as to whether point number 3 as to any other remedy as deemed fit and proper. The fact that there has been an obstruction being made by the delinquent workman was proved and was also admitted in the written statement by the workman the same obstructions of cause in the opinion of this court would come within the ambit of misconduct as stipulated in clause 10A5, 10B5, which stipulates quarreling, fighting, or causing disturbance prejudicial to good order. The learned labor court, however, did not decide the said aspect of the matter. Under such circumstances, this court is therefore of the opinion that as the fact that as it has been clearly proved and duly admitted, the misconduct in terms with clause 10(b)(5) is proof against the delinquent workman. It is under such circumstances this court therefore. Now what fine? What fine? You have already taken 50%. Be that as it may, this court therefore is of the opinion that the learned labor court had therefore rightly interfered with the order of dismissal of the work delinquent employee. The learned labor court had only granted backwage of 50%. This court is therefore of the opinion this court is not inclined to interfere with the said award. The payment of the 50% of the back wages, in the opinion of this court, would be the sufficient punishment for the misconduct in terms with clause 10(b)(5). And as such, this court is therefore of the opinion that no further penalty is required to be imposed upon the delinquent employee or a workman for violation of, for misconduct in terms with clause 10(b)(5). Accordingly, the instant petition, therefore, stands disposed of without interfering with the judgment award dated 6/7/2010 for the reasons above mentioned.
Deeply obliged.
Mr. Goswami, the term dissolute which have been taken, I don't know where he got this book. In something that a person who seeks sensual pleasure. How does this have?
Since 2007,
How?
on the basis of the selection process. I am unconscious,
You have been appointed pursuant to a selection process.
Lordship.
Then
Then there is a case, Lordship.
what is the term of your selection? There's no term.
As per advertisement,
Yeah. What is the average advertisement?
page 30, annexure 3, Lordship.
Page 30.
Lordship.
In the interest of public service and consequent upon reconstitution of the project by selection committee under the current selection of partially modified. Now, this is only the selection committee.
Lordship.
Now,
And
what
I
is
would
the
say that,
advertisement?
Lordship, page 29.
Page 30.
Page 29 for a moment. Lordship.
Now, that is the selection committee.
Selection committee constituted project-wise selection committee. Selection committee for the entire project, Lordship.
Then there was this office notice. 13/3/2007,
That is the advertisement.
and on the basis of which you participated.
Lordship, we participated, we were selected
Okay.
and we joined in the post, Lordship, on 12/7/2007, Lordship.
Hmm.
We have joined in the post, Lordship.
Okay.
And thereafter, what happened, Lordship? The government of Assam was pleased to issue notification, two notification, one for 6 scheduled areas and another for entire rest of Assam, Lordship.
Hmm.
And that was issued on 31/8/2007, Lordship. After completion of the selection process.
Okay.
Now, the selection committee held that the sub-divisional level committee held that the selection committee acted beyond jurisdiction. And that is why recommended state selection,
And you have challenged that document.
Lordship.
Where is the document?
Lordship, page 43 annexer.
And what are these various writ petitions filed?
Lordship, that was the series of writ petition filed. A series of writ petition filed, and this honorable court was pleased to dispose of the same by order dated 10/12/2009, directing the constitution of subdivisional committee and inquire about the thing where the irregularities found. But in our present case, Lordship, kindly peruse page 44, Lordship.
At page 44, yes.
Lordship,
We are concerned with Govardhana.
Govardhan ICHS project. Subdivisional committee opinion that the selection committee constituted for BTC area exercised its power beyond its jurisdiction by selecting candidates in non-BTC area arbitrarily and without jurisdiction authority.
Then, same.
Lordship, same, all the same.
We are concerned with only the Govardhana.
Then
ICT.
ICHS project. Because
And
Lordship,
why so many people are here?
in the earlier,
Writ petitions? How many
Lordship,
petitioners? Why so many petitioners?
because
How many Govardhana ICDS project how many people?
107 selection process was conducted for 107.
Mr. Dhar, what is this? In one ICDS project, how many people are there? Anganwadi?
My lord, if it's an Anganwadi center, we have hardly have 4 or 5 people at maximum. That is what my lord, actually, I could not examine the whole thing. I don't have a copy. It's an old case. my
But
lord.
there are 84 petitioners.
Lordship,
How is it possible?
Lordship, there are lots of Anganwadi centers. Lordship. In Anganwadi centers, Anganwadi worker and helper. So,
One.
Lordship, that will be virtually 84 divided by 2. 44 around that, 42.
42 centers under the ICDS project,
Lordship,
Govardhana.
Lordship. There are a lot of centers. Lordship. In a particular phase, that selection process is conducted for.
Now, who you were selected by the BTC?
Lordship, because the project mostly consists of BTC area under Baska district. Now, part of it under Borpeta district.
So then how can the BTC people do it?
Lordship, that is why I am submitting, Lordship. After completion of the selection process, Government of Assam issued notification, 2 separate notifications. One for 6 scheduled area and other rest of the state. So that cannot be have retrospective effect. Lordship. Because our selection process already conducted, we selected.
Understood, but if it is not the authority to do that, then how
Lordship, that is why we showed the constitution of the selection committee. Lordship. It is project wise, not territory wise. But the entire project. Lordship.
So you say that
Lordship.
the selection has to be made project wise.
Project wise.
It has nothing to do with 6 schedule or 5 year.
After 31/8/2007 notification, when it come into force, thereafter it can be. Lordship.
Where is the government's decision? So many repetitions is what? My goodness.
Similarly situated.
The challenge today is the selection of appointment as to be gathered candidates for appointment to a not permanent selected having regard to the so and so the amendment and so in one thing. He is not possible on the part of the commission. Now, why have you enclosed this judgment of Justice B.K. Sharma?
Lordship, because of pursuant to that judgment, Lordship, page 43, annexure 5, that is the government decision, Lordship.
In pursuance to the Honorable Court's order passed on so and other cases of 2007 and in government so I am directed to state the recommendation as indicated in the remarks of the filing for the you are hereby requested to take next step for government. This is the 2nd July.
Lordship, 2nd July 2011. Lordship.
Okay, no, you are saying that there has been a bifurcation. When?
That I have not annexed, Lordship, but government has filed an affidavit, Lordship,
Yes, where?
in which
Oh, Mr. Yeah, now at that point of time, both the writ petitions were together. There is no file.
No file, Malad.
Both the writ petitions are here together.
Together.
Lordship, they have filed on 18/1/2012.
This is filed by respond number 1.
Lordship.
Respond number 1. State of Assam Commissioner Social Welfare.
Lordship.
Requested Govardhan actually is located in Baksa within the jurisdiction of BTC. However, some of its areas falls under Borpeta district, which is non-written. As per norms, the BTC authority implements various child remand of the social welfare through the projects located within their jurisdiction. Then that as appeared from the evidence, the BTC of the Constitutional Selection Committee on demand for engagement of the committee is against the Pickett Social. He mentioned that no response to be placed regarding the fiction of skill for the
Page 13, annexure C, Lordship.
constituting two separate selection committees for the area covered by law. This selection committee was done after that, after your selection.
Lordship, page.
Your selection was happened on 21/7/2007,
Lordship.
and these circulars were issued on 31/7.
31/8, 2007. Page 13 may kindly be seen for a minute.
Pertinent to mention that one of the regularities cited in so and so is that the BTC acted beyond it. The Honorable, while observing the large number of petitions are filed regarding similar irregularities, the scope of all the directive which is pertinent to the grievances of the execution of the committee and who is appearing for BTC? BTC is a party.
Lordship.
You are for BTC also, Mr. Dhawan?
No, man.
What is this earlier notification of 12/3/2007?
That is state-wise.
Huh?
That is a state of common notification letter
Oh, which one?
for the entire state of Assam. And Lordship, for a moment, page 7 may kindly be seen. That will clear the system. Page 7, and exact B lot of the affidavit. Lot.
Eight?
Page 7,
Yes.
and exact B.
Hmm.
This is the notification for the state of Assam.
Hmm.
And page 13 is the notification for the 6th schedule area.
Hmm.
And these two notification has been issued after completion of our selection process.
Were you appointed?
Yes, Lordship, we have been appointed prior to 12/7.
Where are your appointment letters?
We have not annexed the appointment letter.
Then? Mayor selection would not do. You have to be appointed. Isn't it, Mr. Dhar?
Yes, engaged letter, engagement.
These are engagement ballot. Once we appoint engage ballot, we'll give an engagement letter, my lord.
So without the engagement letter,
My lord.
you can't be, isn't it?
Yes, my lord. There has to
Your
be an-
right will only accrue on the basis of the engagement letter.
Lordship, we have been working. We were working at the time of this decision. Letter. We were already working at that time.
No, you were selected.
Engaged
You
and
say,
Lordship.
no, you say that you were selected
Lordship,
on a particular date. Where is that? You were selected on 21/7/2000. Results were declared on 21/7/2017.
Lordship.
7.
7.
The notification thereby bifurcating came on 31/8/2007.
Right.
Okay. Did you have the engagement letters prior thereto?
Lordship,
Where is it?
we have not annexed this.
Then-
Because we
How
are.
will you know?
That is that is what I asked him, that whether you are engaged.
Huh?
If they are not engaged, my lord, of course, this select list will not survive.
No, it won't. The
Then-
select, it is only a select list.
No, Lordship. Prior to issuance of notification, we were engaged and we were working. What happened, Lordship? After this.
No, because you filed the writ petition in 2011.
Lordship,
Now, when did you get your engagement letter?
in the
Where's
year-
your statement out here that you have got your engagement letter in between that?
Because if you go by the record, 21/7/2007, result was declared.
Then 31/8 you came,
Yes.
you bifurcated it.
Ah,
That means in the meantime, they have to be given the engagement letter.
engagement.
Where is it? Where have you mentioned? Because this writ petition was challenged in 2011.
Exactly, my lord.
Then
Para 5, we have
para 5.
page 15. Lordship.
Yes. I had carried out the appointment to the the aforesaid advertisement was made for appointment of. No, where is it? You have stated that you have got your selected the appointment letter. The engagement letter, where is it?
Lordship. Para 8 may kindly be seen.
Para 8.
Lordship, page 18. Lordship.
Hmm. Yes. Where is it?
That the petitioner had joined as the Anganwadi worker and Anganwadi helper in the respective Anganwadi centers as indicated in the prospectus during May 2007.
How could you?
Engagement.
No. How could you? Your select list was decided on 21/7/2007.
July,
How could you do it on May 2007?
2 months ahead.
Hmm.
Lordship, what happened? Let me start. Because we are working as Anganwadi worker and helper. Some of the candidates who have participated in the selection process, they approved the post. About which we have annexed the order.
But there in that order, It has been held that there has been, the BTC had acted beyond jurisdiction.
Yes.
No,
Yes.
that is not in the order. but
No,
it
that is there in the order.
It is in the lordship, subdivisional committee report. Lordship.
To the Constitution of the Environment.
The allegation of the party.
Yes, we are paying for BTC. Mr. Bhavdari, get all the one, I think somebody appears, no? Without the BTC, it is very difficult. So some of the petitioners here were petitioners there also.
No. Oh, no, no, cannot be. No. Because these are the person who have participated in the selection process and.
That is pursuant to 31(3).
Lordship.
This is after 31(8).
No, prior to that.
When was, because these are all writ petitions filed when? These are all writ petitions filed in 2007, 2007.
Lordship.
So where your selections also been challenged,
Some of the candidate selection process was
challenged.
challenged.
So when it is being challenged, so all these things have been relegated to the authority.
Lordship.
Then
Yes, that is why we have challenged the decision of the sub-divisional level committee. In one hand, our contention is that the selection committee.
no, Mr. Counsel, first and foremost,
Lord,
your right, you cannot have a right on the basis of a select list.
Lord, that is correct.
Your right only will fructify when you have an engagement letter.
Lordship.
But
We have engagement letter, Lord, at the time.
But how are you saying that you were working from May 2007
Lordship.
when in effect the select list was published on 21/7/2007?
Lordship, we have categorically stated in the first title regarding the center number, where we are working. Lord.
I'm not concerned.
Lord.
The select list was there was a selection done by the BTC. The select list was published on 21/7.
Thank you.
If it was published on 21/7, how can you work from May 2007?
Right. Because Lordship, we have not enacted this engagement letter.
Why?
Because we are already working
Why?
about.
No, your right will only be on the basis of engagement. You are saying that, look here, my right has already fructified, and as such, now on the basis of a bifurcation being made by the state government on 31(8), these people cannot stop me.
Lordship,
That is your case. But where is your engagement letter?
because we are working about who is there.
Understood, Mr.
Hello.
Counsel. I am listening to that. You have stated to be in May. You can't be on May.
Lordship, that may be some mistake, Lordship.
Why haven't you engaged the engagement letter?
Lordship, there is. But if, we may be allowed to annex the engagement letter, Lordship.
Okay, Tuesday, next Tuesday.
Because most of the petitioners will give us some more time.
2011 matter.
I will file an affidavit and enclosing all the engagement letter of the petition.
Okay, next Thursday. And pay the court fee.
Because since it is a matter of 2011, Lordship.
So how can 104 or 84 petitioners file and one get one fee?
We are only Anganwadi worker and helper, Lordship.
And help it. And you are enjoying a stay.
Lordship.
And tomorrow, if you lose your job, what is going to happen? Are you going to return the amount to them?
No, we cannot.
No, you have to.
Because another point is that, Lordship.
There is no other point.
Regional level committee never issued any notice to the present petitioners. So they are not.
That's the
hired,
concern.
Lordship. That is one of the ground. Lordship.
That is another aspect. You want this matter to be relegated back to the authority.
Lordship,
You
let's
say-
annex that document, Lordship.
No, you want,
Okay,
I can relegate it back to the authority. The authority will look into it. You want it? I'll be happy. Yeah.
Let me
You
annex
save
that-
yourself with the payment of
satisfy that.
4,000 rupees. You save yourself with 4,000 rupees. Tell me.
As your Lordship said. As your
Otherwise, you have
Lordship
to
said,
pay. Otherwise, you have to 4,000. Because you have to pay 84
that you-
into 50, 50 at 60. It's 4. It is 4,800. Yes, Mr. Bora. Your matter, we are waiting just for you.
Sorry, my lord.
Yeah.
The Congress I have seen it just now, the BTC, it is BTAD. That's why we missed it. But
So BTAD and BTC.
that's simple.
Now here is interesting. It is because of you he's claiming right. What has happened? In respect to one Govardhan ICDS project, there was a selection held. In that selection, this Govardhan ICDS project is partly in BTC, partly in what you call the Barpeta district. Now, the BTC, what they did, they held a selection for the entire Govardhan, which included non-BTC areas. Once that has happened, they issued a select list on 21/7/2007. Okay. The petitioners here claim that they were appointed in the meantime after that. Although in the petition, they say they have been working from May 2007, which this court has to ignore. Taking into account that their select list was on 21/7/2007, they couldn't have been working from May. It's not possible. On 31/8/2007, the government bifurcates, says that these are the rules for Assam and this is for the section. In the meantime, there are various petitions being filed challenging their selections. There and various others, many petitions were. Now, by a judgment, Justice B.K. Sharma said that all these matters would be decided by a committee to be made by the Social Welfare Department. And the Social Welfare Department shall form a subdivisional committee for that purpose. The subdivisional committee had come up and given a report out here to look here. These are some parts are BTC, some are not. And as such, there will be a fresh interview, fresh selection. Now, pursuant thereto, they have challenged it. saying that we are working out there, you can't disturb. So from 2011 onwards, they are enjoying a stay for the last 12 years. They have not engaged the engagement letters. Because here it's a very relevant thing. They were selected, maybe, on 21/7/2007. In the meantime, the bifurcation happened on 31/8/2007. So they had to get the engagement letters in between to have a right. Otherwise, men remaining in the select list would, they have not engaged them. But that aspect was not looked into. A stay was granted, it was allowed. So it is all because of you this is happening. In a very concise manner, this is your case. Is it?
Only thing is that since 2007, we are working and we are getting the salary also, remuneration. So there is no question that we are only selected, not engaged.
No, understood.
Lordship, to substantiate my point, I will enable the engagement.
No,
letter.
no. Whether you see the movement, those people who this court's opinion, prima facie opinion is those people who were selected in BTC areas, there's nothing to disturb with. But those who were not selected in the BTC area, but in the meantime, that thing has come and we are not engaged. Those who were selected in non-BTC areas, but in the meantime, prior to the engagement letter, the 31/8/2007 has come in. You won't get.
We are prior to that.
How can
To
we
satisfy that.
Mr. Dhar, what to do?
My lord, either he can file an affidavit, bring on record this, whether they were engaged, the engagement letters. Or else, my lord, but this was the matter directing the authorities to take a call on it. My lord, we'll examine the matter. Because, my lord, that is very vital as to whether they were engaged. If, my lord, they were not engaged by an order, my lord, by an engagement letter, that select list will not prevail, my lord. It's long gone.
Huh? No, just 1 minute, huh? Just 1 minute.
They were engaged from something from May.
Election started. Election result declared.
Oh, there is another big problem, huh?
My lord.
You have an extra copy? No, no.
No, my lord, I will borrow it from my.
You just give him a copy of the petition as well as the affidavit so file. Just give him just for the sake of it. Let me show him one. Just copy of the petition. Kindly come to page 29 of the petition.
My lord.
This was the selection committee which was formed
My lord.
on 18th September 2006. This selection committee selected the petitioners.
My lord.
Okay.
My lord.
Now see who are the chairman. Chairman is this Makhan Saroge, MCLA, so and so. Then member. Who are the members? Okay.
My lord.
Okay. Now kindly come to page 13 of the affidavit.
My lord. My lord.
Now the selection committee is changed
Yes,
on 31/8/2007.
my lord.
So not only the area is important,
My lord. The entire select.
selection goes.
Selection
If
goes.
in the meantime, they have not got the engagement letter.
My lord.
Because this selection committee is different.
Very different, my lord.
It has the principal secretary or his representative,
These are all
program officer, Kokrajhar,
These are government officials.
So and so, concerned DC office here this is no DC business. Then concerned member of the autonomous council, concerned medical and health officer, concerned CDPO. CDPO is there, but the member secretary is the deputy directors. You see the
Social
important
welfare.
thing, the program officer, Kokratar / deputy director, SW,
Social-
social welfare, NC Hills. But how do you take care of this notification for BTAD?
My lord, we'll take note. One thing, the concern of this, these are all BTC officials, my lord. This principal secretary,
Because that is for
Oh,
fixed
oh.
schedule area.
six,
No,
BTC, my
understood.
lord.
No, what they say. Principal secretary or his representative, no problem. Number two,
Program-
program officer, Kokrajar,
Kokrajar.
/ deputy director, and SW NC Hills. So Kokrajar will be BTAD.
BTAD. BTC, my lord, Kokrajar. Concerned DC, my lord, so concerned DC is of the district.
Or his representative. These are not there, na?
That notification was subsequently issued. Subsequently issued.
No, this was issued on 31/8.
Concerned
So you have to have your engagement letter in the meeting. We take it up on next Thursday, huh? Or you want a verification, should I remit it back to the authority to make the verification? Because that is a fact-finding authority.
My lord.
You have to find out one thing as to whether these petitioners were issued engagement letters so that you can ask them,
Yes,
you can
madam.
submit there.
Submit. And this was for.
Because if the engagement letter, Mr. Counsel, I make it very clear, if the engagement letter is not there, your entire selection goes.
Accepted. Because I am very sure that our
Very well.
prior to issuance of the subsequent notification.
In fact, my lord, if Lordship, that affidavit, page number, Lordship just pointed out that notification of 31 August 2007. If notification is for two 6 physical areas, for BTC also,
And
for
absolute-
NC also.
Understood? There's no problem on that. No, here what has happened is this. This page 29 is the selection committee.
Yes.
On the basis of that, they have selected these
Okay,
people. This selection happened on 21/7/2017. Very interesting. 21/7/2007. After 1 month, 10 days.
New notification.
This,
This notification.
so they have not engaged, brought on record any of the engagement letters. Now, if the engagement letters are there, then a right would accrue upon them because they have been selected. But if the engagement letter is not there, Bruce, the entire selection process has gone for a win.
Case, their challenge is to do the fact finding. This would be good.
What to do? Shall I remit it back?
My lord, it's a now totally, it will be, have to be fact finding, whether, so records has to be looked into, my lord, is it verified? Now,
Now, I think you need to also issue notice to everybody,
exactly,
hear them and ask them to find out.
find out,
I
they have
think
to
that
come
is
and submit their documents, my lord,
That is the best
that
way.
is
na?
the basis, my lord. And now, it BTC area, na, BTC.
Principal secretary.
Principal secretary will do it. No,
You'll do it.
Principal BTC will have to do it.
he has to send a notice, they will come and they will submit their documents, whatever they have. If they are engaged, they are in, if they are not.
Yes, that can be done. Lord. We'll show our credential.
The instant petition has been filed, challenging The recommendations made by the subdivisional level committee Borpeta in respect of Govardhana ICDS project for fresh interview against the post of Anganwadi worker and Anganwadi helper held by the petitioners. Semicolon. For setting aside the government letter issued by memo number SWD.153/2011/66 dated 2/7/2011 issued by the Joint Secretary to the Government of Assam Social Welfare Department dispute, thereby directing necessary action of fresh interview in respect of Govardhana ICDS project against the post of Anganwadi worker and Anganwadi helper held by the petitioners in terms with the findings of the recommendation of the subdivisional level committee Borpeta. Semicolon. For setting aside of the letter by memo number BDD-2010/ICDS/HC/288 dated 27/7/2011 issued by the chairman subdivisional level committee Borpeta in respect of Govardhana ICDS project against the post of Anganwadi worker and Anganwadi helper held by the petitioners, and for a direction upon the respondents not to give effect to the recommendation of the letters by memo number SWD.153/2011/66 dated 2/7/2011, as well as memo number BDD-140/2010/ICDS/HC/288 dated 27/7/2011. Next. Altogether, 84 writ petitioners have joined together in filing the instant writ petition. It is the case of the writ petitioners that on 18th of September 2006, the Deputy Secretary, Boroland Territorial Council, Kokrajhar, had constituted a project-wise selection committee for selection of Anganwadi workers and helpers for Govardhana ICDS projects pursuant thereto on 13/3/2007, an advertisement was issued the petitioners herein claim that they were selected in the said selection process and were thereupon appointed from the pleadings. It is not clear as to when the petitioners were appointed or engaged as Anganwadi helper or worker and or Anganwadi helper. Nor there is any documents placed on record as to when the petitioners were engaged as Anganwadi worker or helper. Be that as it may, on 10/12/2009, no, be that as it may, the selection which was carried out by the Boroland BTC authority for engagement of Anganwadi worker and or Anganwadi helper were put to challenge in various writ petitions filed in the year 2007 and 2008. All these writ petitions were disposed of by an order dated 10/12/2009 by a coordinate bench of this court, issuing various directions relevant herein to mention that this court had directed the Commissioner and Secretary to the Government of Assam in the Social Welfare Department to scrutinize the grievances of the petitioners by constituting various committees, district-wise or subdivision-wise. Pursuant to the said directions, various subdivisional committees were constituted. The Joint Secretary to the Government of Assam, Social Welfare Department, had issued a communication to the Child Development Project Officer, Govardhana ICDS project on 2nd of July 2011, thereby enclosing the recommendation of the subdivisional level committee, in respect to the Borpeta district. In the said recommendation, there was a reference being made to 5 writ petitions which were in relation to Govardhana ICDS project, and it was recommended for fresh interview. The petitioners who were engaged pursuant to the selection process, which culminated with the select lists being published on 21/7/2007, being agreed by the said recommendation, has therefore approached this court. It reveals from the records that this court, while issuing notice, had also directed by an order dated 24/8/2011, not to hold fresh selection pursuant to the communication issued on 27/7/2011, issued by the Chairman, Subdivisional Level Committee, Borpeta. The interim order has been thus extended from time to time. The learned counsel, appearing on behalf of the petitioner, submits that the petitioners herein pursuant thereto have been continuing since their date of engagement and till date have been receiving their salary. What do you say? Salary or
Honorary.
honorarium? Good stuff. It reveals from the records that the social director, commissioner and secretary, that the commissioner and secretary to the government of Assam Social Welfare Department had filed an affidavit in opposition on 18/1/2012. In the said affidavit of opposition, it was mentioned that the Govardhana ICDS project is located partially in Baska district within the BTC authority, and some of its areas falls under and partially under the Borpeta district, which is the non-BTC area. It was further mentioned that the BTC authority constituted a selection committee by the notification dated 18/9/2006 for engagement of Anganwadi workers and Anganwadi helpers. It was mentioned that the said committee had issued an advertisement on 13/3/2007, and the results were announced on 21/7/2007. It was further mentioned that there was no record could be traced regarding jurisdiction of the BTC authority in respect of the selection of Anganwadi worker or the Anganwadi helper in non-BTC area that falls under the same project. It is however mentioned that on 31/8/2007, the government of Assam have issued 2 notifications. One of such notification was in respect of the government of in respect of the 6 scheduled areas, and the other was in respect of the rest of Assam. A further perusal of the said notifications show that a totally separate selection committee was constituted and various guidelines were laid down on the basis of which the selection was to be carried out. In the backdrop of the above, let this court therefore take into note the respective submissions made by the learned counsel for the parties. The learned counsel for the petitioner submitted. Your name?
R. Islam. R. Islam.
R.H. Khan.
R. Islam.
R. Islam. Mr. R. Islam, the learned counsel for the petitioner submitted that the petitioners herein were engaged pursuant to their selection and prior to the issuance of the notification dated 31/8/2007. And as such, a right had been created in favor of the petitioners. He further submitted that the notifications dated 31/8/2007, whereby for the first time the government of Assam had segregated on the had defined had segregated. The ICDS projects on the basis of regions oblique area,
Territorial.
on the basis of territory. Was not there earlier. And the ICDS projects were being run on the basis of projects, having no relation whatsoever as regards the territory. He therefore submits that as the petitioners were duly engaged prior to coming into effect of the notification dated 31/8/2007, the engagements of the petitioners as Anganwadi helper or an Anganwadi worker oblique helper cannot be disturbed on the basis of the recommendations so made by the subdivisional committee, which have been impugned in the instant proceedings. On the other hand, Mr. R. Dodd, the learned counsel appearing on behalf of the Social Welfare Department, submits that from a perusal of the affidavits so filed by the Commissioner and Secretary to the Government of Assam Social Welfare Department, it would transpire that the results were only declared on 21/7/2007 and pursuant thereto on 31/8/2007. The notification has come whereby a new selection committee has been appointed, constituted, and the total and the entire and a new set of guidelines have been issued. He therefore submitted that if there has been no engagement of the petitioners prior to the issuance of the said notification, the petitioners have no right, in as much as merely being selected would not confer a right to be appointed. The learned counsel, Mr. S. Bora, the learned counsel for the BTCR, further submitted that as to whether the petitioners were engaged prior to 31/8/2007 and as to whether they were at all engaged or selected requires a fact-finding inquiry which can only be done at the level of the officials in the BTC department.
PC under principal secretary.
BTC department. He submits that such fact-finding inquiry can be done under the principal secretary of the BTC, whereby the principal secretary may form committees for making such verification after giving due notice to the petitioners. This court, upon perusal of the materials on record and I've heard the learned counsels for the parties and have also perused the materials on record. The pivotal question which arises out here as to whether the petitioners herein were engaged, were at all selected in the results which were pronounced on 21/7/2007, and thereupon was as to whether the petitioners were issued engagement letters as Anganwadi worker or Anganwadi helper prior to 31/8/2007. This court is also of the view that if there has been no engagement being made to the no engagement letters being issued to the petitioners, even upon being selected prior to 31/8/2007, the petitioners would not have a right to continue to remain the right over the post held by them on the basis of the interim order passed by this court. This court further is of the opinion that these aspects of the matter would require a fact-finding inquiry to be conducted by the BTC authority under the authority by the BTC authority. Therefore, in that view of the matter, this court therefore disposes of the incident with petition with the direction to the principal secretary, BTC, to constitute a committee of the committees for making verification as to whether the petitioners herein were duly selected in terms with the selection proceedings of which the results were announced on 21/7/2007 and in pursuance thereto, as to whether the petitioners were issued engagement letters prior to 31/8/2007. It is made clear that if the petitioners upon upon verification it is found that the petitioners were petitioners, or if it is found that the petitioner or any of the petitioners were duly selected and thereupon engaged by issuance of engagement letter prior to 31/8/2007, a vested right has been conferred upon the petitioners to continue in respect to the said posts so held. With the above observations, the petition stands dismissed. The said exercise be also done. It is further made clear that the said exercise be completed by giving due opportunity to the petitioners and within a time frame of 6 months.
Not sure.
Obliged.
I will continue the interim order till the finalization of your. The interim order by which the petitioner's services were protected would continue till the verification process is complete. Yes, 3. Where is the petitioner? They are challenging some Annexure 13 and 7 series.
Yes,
What are those?
thereby my lord, the annexure 7 series, my lord, are the respective communications made by the, my lord, Director of Land Records to the petitioners, whereby, my lord, they have been asked to give a foundation undertaking.
Oh, they are not giving.
They are challenging that, my lord.
Why?
because they are claiming, my lord, the benefits under the old pension rules, 1969 rules. Now, admittedly, my lord, they were inducted into service, my lord, in the year 2011.
10.
10. So it is, my lord, not a regularization per se.
There is no regulation. What regulation? Regulation is different. Concept of regularization, people are making it. Regularization is not a concept of recruitment.
My lord is correct, my lord, why I am making that submission? They are claiming their past services, meaning thereby, my lord, they want to draw up a line of continuity from the date of their initial induction, rightly or wrongly in the service. And my lord, that
Were they getting pay scale?
my lord, post, my lord, their recruitment by following due
No,
process
no,
of.
earlier.
No, please. Lordship, can you take up the affidavit filed by the DLR, my lord? I beg again, my lord, I'm,
No, they were given pay scale.
my lord, appears to be not, my lord.
Order is in the interest of public service and subject to the observations of AR so and so who was appointed as film developer and terminated, they were reappointed as gene corrector grade 2 in the modernization of map printing section under joint so ever against backlog STP in the scale of pay of so and so plus other admissible. A service may be terminated at any time without assigning any redress. How are these appointments being made? Illegal appointments.
Illegal appointments. Illegal appointments, they were terminated. Against their termination, my lord, they approached this honorable court by filing various writ petition. And this honorable court, my lord, set aside that termination order only on the count that, yes, you ought to have issued notices.
No, the division bench later on said in this matter, one of the matter was before the division bench says that unless you follow, keep them, don't disturb them.
Yes, that's right.
Once there were 2 termination letters.
True termination. Now, the fact remains, my lord, that there were 2 periods, my lord, where they have effectuated service. The first length of period, they were under irregular and illegal appointment. My lord, then their services were terminated. They approached this honorable court interfered. And on interference by this honorable court, they were re-engaged. They were reappointed.
They
And-
also had service book.
Yes.
Huh?
My lord, after face appointment, my lord.
No, not before that.
No. Because it is the pleaded case in the affidavit. But may kindly take up the affidavit, my lord, filed by the director of land record. No, আমার affidavit DLR affidavit কোন?
ওই নতুন এইখন ভাঙাই দিব 2011 মেটাৰবোৰ লৈ লৈ এইটো কপি নাই আৰু
DLR affidavit file কৰিছে আপুনি? Yeah, মানে? সেইটো কোনে respondent number কিমান? In the affidavit in opposition, my lord, that has been filed by the respondent number 4, my lord, on 3/1/2013. And that is the only affidavit, my lord, filed on behalf of the respondents. পিছৰখিনি দি পিছত ঠিকে আছে, প্ৰথমখিনি নহয় ন? এইটো প্ৰথমখিনিহে বিচাৰি আছে। First service benefit লাগে।
চলো The petitioners, by way of the incident with petition, the petitioners who are 3 in number have joined together to file the incident with petition challenging the action of the respondent authorities in refusing to grant the petitioner their past benefits, past service benefits, and also the benefit of the pension and pensionary benefits in terms of the Assam Service Pension Rules 1969. Next. The case of the petitioner herein is that the petitioner number 1, 2, and 3 how does the 2 come into the picture? The petitioner numbers 1, 2, and 3 were appointed in different grade 3 and grade 4 posts in the office of the Director of Land Records and Surveys, Assam. In the year 1999. Thereupon, on 17 to 1999, the services of the petitioners were terminated. The petitioners, therefore, were terminated on the ground of being appointed, the horse, the recruitment rules. The petitioners approached this court by filing a writ petition being WPC number 6516/1999. On the basis of the interim orders, the petitioners continued to render their services. By an order dated 13/6/2008, the said writ petition, that is WPC number 6516/1999, was disposed of. Thereby setting aside was disposed of, thereby dismissing the petition. It was, however, provided that in the event of initiating any regular process of selection as per the recruitment rules, it would be open to the petitioners to sit in the said selection, and the respondents were directed to consider the condonation of age bar of the petitioners if same is required to be done. What are the names of the petitioners? Dalimit Kaya, Peku, and Swenpo. Rupa Pai. There is another petition which was allowed. It appears therefrom that it further appears that thereupon the petitioners have approached this court, the division bench of this court, by filing a writ appeal which was registered and numbered as WA number 166/2008. By an order dated 26/2008, the division bench of this court, taking into account that the petitioners have been working for the last more than 10 years, were permitted to continue in the services till the regular selection process is over. Inasmuch as at that relevant point of time, the authorities was contemplating to hold the selection proceedings. It further reveals that thereupon the petitioners, the services of the petitioners were again terminated. Thereupon, what happened? Subsequent thereto, it further reveals from the records that the selection process was initiated by the respondent authority and by separate order dated 10/12/2008, the services of the petitioner were again terminated. The said orders dated 10/12/2008 was challenged in WPC number 525/2009. It was the case of the petitioners before this court in the said writ proceedings that the posts held by the petitioners were not covered by the advertisement dated 16/4/2008. It was the case of the petitioner, na, in the said petition. That it was the case of the petitioners that the advertisement dated 16/4/2008 was not in respect to the post which the petitioners were holding. And as such, the termination of the petitioner by the order dated 10/12/2008 was not in conformity with the order dated 26/2008 passed in writ appeal number 166/2008. It was therefore the submission that till the posts which were held by the petitioner were advertised, the petitioners should be allowed to continue their services. This court, by then order dated 25/2/2009, disposed of the said writ petition holding inter alia that the principle underlining the division bench order dated 26/2008 passed in writ appeal number 166/2008 should be continued, and the petitioner should be allowed to continue until the posts held by them are duly advertised and filled up in accordance with the recruitment rules in force once the requisite approval of the Finance SIU department is obtained. It further reveals from the record that on (25/7/2010), the posts held by the petitioners were advertised along with other posts. Huh?
Yes.
Along with other.
Another post.
The petitioner participated in the said advertisement, said selection proceedings, and by separate orders dated 13/12/2010, the petitioners were selected and appointed and brought within the affairs of the government. What is the term used? Not
Service,
within the,
not within the service of the government. Rule 31,
no. You have the old pension, new pension.
my lord,
See that notification of,
yes, my lord. Yes,
see that notification. In my judgment, if you are looking into it, it will be in paragraph number 7 or 8. I quoted that notification.
Yes, got appointed so and so in connection with the affairs of the state government,
Were appointed and in connection with the affairs of the
in a connection with the affairs of the state government of Assam,
Assam.
which are born on pensionable establishment.
So, by separate orders dated 13th of December 2010, the petitioners were appointed to the services,
To the services and posts
were appointed to the services
and posts
and posts
in connection
in
with,
connection with the affairs of the government of Assam,
yes, my lord, state government of Assam,
which were
which are born on pensionable
posts.
establishment,
Established.
my lord.
In the said orders of appointment, it was mentioned that the petitioners would be covered under the new pension scheme which came into effect, came into effect, which was brought into effect with effect from
My lord,
1 to 2005
my lord,
on the basis of an office memorandum dated
my lord, 3/10/2009.
3/10/2009. The petitioners, therefore, the petitioner hearing are agreed. No. The petitioner upon taking the appointment upon accepting the appointment, refused to give the undertaking and have challenged the various directions so issued. Upon accepting the appointment orders, have now challenged, have however sought for their past service should be taken into account for the purpose of their pensionary benefits, and they should be granted the benefit under the old pension scheme in terms with the Assam Rules Service Pension Rules 1969. I perused the materials on record and have also heard the learned counsel, Mr. Arthur Pujari, the learned counsel appearing on behalf of the finance department, has submitted that the issue involved in the instant case is duly covered by the judgment of this court in the case of Purnima Holt versus State of Assam, reported in
My lord, 2000,
very widely.
2023 one, my lord, SCC online. 2023 SCC online, my lord, I have
1065.
1065. my lord. WPC number is, my lord,
The
6403.
learned counsel for Mr. Arbor Pujari had further submitted the appointment of the petitioners were illegal, and the initial appointment of the petitioner in the year 1999 were illegal and dehors the recruitment rules. And the petitioner continued to remain in service on the basis of an interim order being passed at the time of filing of the writ petition on writ petition, that is WPC number 6516/1999. And thereupon, on the basis of the order dated 26/2008 passed in writ appeal number 166/2008, and the order dated 25/2009.
Yes. And WPC 525 of 2009.
525/2009.
My lord, my lord.
The learned counsel further drawing the attention to the order dated 25/2009 further submitted that it has been all along the case of the petitioners that they should be allowed to continue till the selection is being carried out. And now upon being selected, the petitioners have now been brought within the cadre, within the affairs of the state for the first time. And as such, the petitioners cannot claim the benefit of the past service. Upon hearing the learned counsels for the parties and upon perusal of the materials on the record, this court is of the opinion that it is only on the basis of a regular selection being conducted on 25/7/2000, initiated on the basis of the advertisement dated 25/7/2010, which was followed by an orders of appointment made on 13/12/2010, that the petitioner were for the first time brought within the affairs of like the services of the brought within the affairs of the government of Assam,
Government of Assam, state of Assam,
of the affairs of the state of Assam
in posts born out of pensionable establishment.
imposed. And as such, the case of the petitioners are duly covered in terms with and as such, the petitioners would be covered under the new contributory pension defined pension scheme 2009, which was given into effect from 1 to 2005.
My lord.
This court further makes it clear, would like to clarify, this court further would like to observe that the case of the petitioner this court further would like to observe that as the services of the petitioner were only continued on the basis of an interim order passed by this court in WBC number 6580, and thereupon by then order dated so and so in writ appeal number so and so. The petitioner did not enter. No. The petitioner did not qualify in terms with Rule 31 of the Service Pension Rules 1969. And as such, that period of service under no circumstances can be taken into account for the purpose of computing the pension and pensionary benefits of the petitioner. Under such circumstances, this court does not find any merit in the instant petition for which the petition stands dismissed.
Only one submission, my lord, that office memorandum is dated 6/10/2009. I have wrongly said it.
I thought so, because 310
My lord, 6th. I'm so obliged, my lord. And that other decision which my lord was referring to where senior counsel BT does appear.
BC.
BC does, yeah. That is my lord WPC, my lord. 6
That's
of
not given.
2011. Yes.
It's not there in SEC online.
But I have checked it in the my lord, our website, my lord. In fact, it has not been reported in Monopatra also.
They're not given.
Yes, my that the judgment is dated my lord 2/5/2023 by my lord.
Another judgment is the part of it. That is 70 to 2016. Squarely covered in this case.
Is it?
Otherwise, Punima Hore takes care of everything, my lord.
That is,
Robin Chandra Sharma.
there he had been appointed, huh,
Yes, sir.
in some other post.
Yeah.
So many pension judgments.
This is, my lord, Dilip Kumar Sinha, here, my lord, lordship has taken that, my lord, distinguished that Delhi High Court decision, my lord.
Oh, that's Sandeep.
Sandeep, yes. My lord, it is.
Yes, any other item anybody wants to do?
Apply.
Item number 5, Lordship. In this case, I am appearing on behalf of BD Goswami, Lordship. And Lordship, 5 or 2 years, more than 2 years ago, the petitioner taken a bid from us. Lordship.
I don't know, have to know, please.
And
What is that matter about?
has not been engaged, Lordship. That's why caused this. Lordship.
Oh, this one, stenographer. You are there. Bad kid.
We are
Stenographer, no kid.
no longer communicated with the petitioner.
They have never communicated.
Never communicated.
Is there any interim order?
No, Lordship. There is no. Order. Our name may be strike of Lordship from Uttarakhand. Since we are.
Have you given the notice to them?
Okay, they have taken gift. Petitioner himself, they themselves taken up gift from us. Petitioner. And initially this case was.
You are there? You are there in this case?
Yes.
The upper name to likhibo, yahan none appears for it. None appears for the petitioner, so and so. Yahan likhibo na lage, none appears for the petitioner. Taking into account the above, seems the petitioner is not interested in the matter for which the petition stands dismissed for non-prosecution.
Okay.
Let's see if they come later on. That is the only way out. Yes, what then?
My lord, next is item 6, my lord.
What is that?
That is a termination, my lord. Permanent position bank officer, my lord.
What is that? No,
If not possible today, it can be on Tuesday also. I have no.
oh, that's called the central bank.
Yes, my lord. The only thing, my lord, my submission will be, my lord, limited to, my lord, disproportionate, whether this punishment can be, my lord, on the basis of the material evidence. Because on the basis of their document, my lord, that I did not swindle a single pipe, but because of my misadministration, my lord, the lower official, my lord, some mismanagement. That is.
You are retired. Oh, you have been dismissed. What is
Yes,
your age?
my lord, 70 years, my lord. Retired 2011, my lord, April 2011.
And you were terminated on?
Terminated, yes. Terminated in 2011 itself. Sir. Terminated, yes. Terminated on 28 to 2011.
20?
22/3/2010. 22/3/2010. Original order, my terminated. I filed a statutory appeal ballot that was dismissed on 28/2/2011. by the-
You were not allowed to file your reply.
Yes.
What happened as regards the additional charge sheet which was given? Then did you file your reply?
No.
Yes,
There is
he did not opt for down.
No. First time it's okay.
Yes.
You lost your chance out there because
Yes.
The time had expired on 16/7/2008.
Yes,
Then also the 38/2008 also you did not file.
Yes.
That is their stand.
Yeah.
What do you mean? But what do you say about the additional charge which have been framed? Wherein another 40 lakhs or 41 lakhs?
Altogether, my lord.
altogether.
Altogether.
No, there was
41
more
lakhs.
something.
41.
At that point of time, you were allowed to file.
Yes.
Then
He
what?
did not. He did not. opt.
I did not.
Why?
So,
You should have filed.
yes,
You
sir.
don't have a defense.
left are there, my lord, because I was posted Nagaland. After that, after this Maharipara branch where the incident happened, my lord, during my tenure, then I was posted to Kohima, my lord. There was
No,
very-
everything, all misappropriation happened in Kohima only.
No, my lord.
In
That is not alleged.
Maharipara,
That is the. that may be there.
Huh?
Well, he was in Mohoripara branch.
Maharipara, only in that.
Everything was done. That on that basis, these charges were
But when he was in Kohima,
these
didn't
were
apply.
detected.
Yes, that was.
These were detected. And in one document, I can show from the record, my lord, he was a branch manager. He put a signature on a particular document, which was written as 46,000 by words, and by numerical it was written. By numerical it was written as 46,000, and by words it was written as 40,000, and he put the signature, and that is the from there it found it was detected that some irregularities were there, and while in certain documents it was written as 13,000, but Ujjwal was for 1,000. Well, 1,000 written as 13,000. All these things are there. So
Yes.
all together, these things happen.
Yes, these mistakes.
And
are
my lord,
lapses. I admit, my lord, these lapses. But for that, man, I did not take unfair gain, my lord. That is,
But he is a branch manager. That is the
that
fair.
is the there. Because, my lord, only one line I will read, my lord. Only just later on, when I'll argue, I'll face, my lord. When I filed a statutory appeal and when this impure order was issued, my lord, 2 lines. However, there was no complaint from any such account holder and the bank has not suffered any.
No, no,
loss
Mr.
out of it.
Counsel, wait. The fact that it has been proved, this court is not going to touch it.
Yes, yes.
It is only on the question of proportionate.
Yes, proportional. Because there are minor punishment, my lord.
No, there is not a minor. Loss of confidence, you have to go. There is no way out. But the question is, there are two things. No? One is dismissal and the other is what?
Dismissal, yes, yes, my lord.
There are two types of punishment. One is dismissal and the other is
I was a dismissal which shall ordinarily be disqualified for future employment.
And?
Yes, that is my order, my lord.
and anything else.
Yes, and if we go through rule, my lord, that is, I have the rule, I can supply one rule to your lordship,
Yes,
my lord.
what is else?
Yes, my lord. Because I was penalized under,
Because this court sits till 5, na?
yes,
This court's timing is till 5.
oh,
So
yes.
you they have till
Yeah.
10 minutes.
Yes, because when I was
My lord,
provided penalties, my lord, that is following are the.
You tell me,
Which-
taking everything out here.
Yeah.
What other penalty can be given to you?
Well, if may I read? Yes, yes.
Yes, what other penalty can be given? Taking into account that you have misappropriated, that has been proved, this court is cannot touch it unless you show perversion, which you can't.
Yes, my lord, there are minor penalties such as, my lord.
No, minor penalties, no. You see, bank officials, loss
Yes,
of confidence,
by even,
is
yes,
nothing.
Yes.
Matter, I can't
Yes.
touch in.
yes.
But is there anything else by which you can get pension? It's a question of pension only.
Yes, question of pension.
That part has already been dealt with by this court, my lord.
Where?
While they filed a miscase, my lord.
What happened?
That was dismissed
That is when I.
on the 16/8/2012.
What did you file?
A miscase number 1208. Something like that. Seeking pension, etc.
That was,
By justice.
that was filed in the initial stage, my lord.
And this is an interim one only.
Yes, yes.
Yes, my lord, only thing, my lord,
Therefore, you find tell me tomorrow. This I'll take it up tomorrow. These are 2011 matter. You tell me only one thing. What else punishment can be given so that you can get?
right.
That is the only thing you.
The only thing,
Otherwise, you would have no.
yes, definitely. Because I have tried to find out judgment, my lord. All this discussion, but so far as the bank official is concerned, my lord, it's very difficult, I could not find.
That is very dangerous.
Yes.
Therefore, anywhere any pension can be given because you are now 70 years.
Yes, yes.
The
My lord,
total amount you have misappropriated is 41 lakhs.
no, my lord, I did not misappropriate, my lord. That is on record, my lord.
You are a branch manager.
Yes, exactly.
Three
Three persons were there, my lord.
Branch managers, the banks are more particularly public sector banks. I don't think they require pension. Do they? If they are caught in the question of misappropriation.
I got only one adjustment, my lord. If it is tomorrow, can it be approved second of my
Only second half one.
lord?
Second half. I'll take it just before taking part 2. Today I couldn't do it because the item number 2 it took a long time.
Yes, so many judgment, your lordship.
Tomorrow. At second half. And now take a look. This is the fact. Yes, 7, 8, and 9.
Number 7,
Yes. That is matter pertains to non-payment.
non-payment of the admitted liability. They have already admitted that the matter has been there.
Where is the PWD? Anybody?
They have today filed a affidavit also admitting that we have already submitted our payment for payment.
You are there?
Lordship, I am for the demand, sir, Lordship.
Yes. You have admitted.
Yes, Lord.
And the other one? Where is that Mr. Dhar was there nearby? Is it somewhere nearby?
No, Lordship, not in the court.
And Mr. Babujari also left.
Don't know, Lordship.
The requisition has been already submitted long
The
back.
other one is number 8 is yours. That is also could have been disposed of. Hey, 6, 7, 8, and 9. 6, 7, and 8. 9 to not lage. 9 is you. Why don't you go to civil court? You have a huge amount. Why are you not going to civil court? You are arbitration. It's 6 to 9, it is Kali Didi. Tomorrow we'll take care.
Highly apply. ठीक है जी itu boleh Pak. Boleh Pak.